Is that migrant labor?
No, my lords, this is the unorganized labor.
Unorganized labor.
My lords, I had filed a note on submissions
All right.
on 31.
In response to our affidavits, he has filed.
Yeah,
My
31 January, as per your lordship's order.
Where is that?
There. Have you,
Yes, I have got. I have received the affidavit.
No, you're not filing.
Oh, it's on the top. All right.
My lords, in this context, I'd like to draw your lordship's attention. I haven't got the copies yet, but
Copy of my affidavit?
no. There are certain developments, my lords, which I love. Is that there is a code on Social Security 2020, which has got
that labor code.
Yes,
correct,
my lord.
correct.
But that is supposed to repeal all these acts, 9 acts, my lord.
That's right.
Number 2, my lord, the Odisha government has also come out with a gazette notification subsequent to that.
All right.
And incidentally, the Bandhua Mukti Morcha Supreme Court order has also said that in spite of Code of Social Security, the registration is a pivotal issue. So let registration go on. Therefore, thereafter, welfare schemes, what they are entitled to or not, will be the issue of code. So my sole request, appeal to your lordship is that let the registration happen, which is not, which in my note I've said that there are a lot of anomaly between the earlier affidavits and the present affidavit. So therefore, they have to probably apply their mind and do a better job of it. My lords, in recently, they according to the last affidavit, they have said 3 lakh some odd unorganized workers.
How does one go about registering unorganized workers? How does this happen? I'm not able to imagine.
There are some formats in the last affidavit.
Do they have people who go out into the field and actually meet the workers? How will they do it? Like if they go to a construction site, I can understand.
Yes, my lord.
But there will be so many others.
I think they have to, as per the act, they have to self-declare. It doesn't happen.
That can't happen. Also.
It can't happen.
Let's say I have come from Manipur.
Yes, my lord.
I'm serving in a restaurant in Bhubaneswar.
Yes.
How will I go and register myself?
Yes, my lord. Therefore, they have, I think, the last few orders back, I think, there was an order that the Honorable Learned Advocate General and there will be a meeting of people who are concerned.
I want to know actually the modalities. How does it actually work?
Okay, my lord.
Have you understood how it actually works?
Yes, my lord.
And how do they reach out? Are they enumerators? Just like they do census.
Yes, my lord.
They have to have enumerators who go out of the field and actually see. And this, when you say unorganized,
yes, my lord.
It's not restricted to urban. It also includes rural. It could also be farm labor.
Yes, my lord.
Also domestic servant also
yes,
they can.
Yes.
Domestic servant.
Whole set of activities. We don't know.
My lord, as per
the entire set of activities, which activities qualify for this?
There are several activities.
Even a sex worker, I don't know if a sex worker will be considered as part of this.
No, my lords, not yet. Not yet.
No, I'm just saying, so how do we exclude certain categories of workers and say that they don't qualify for this protection?
Yes, my
ultimately, this is a welfare legislation.
Correct.
Yes, my lord, as per the act, as per registration is concerned, they said that as per section 10, they're saying every unorganized worker shall be registered.
No, how is unorganized worker defined?
The definition of unorganized worker who are coming under this particular category, that is not...
They've said that they have to make an application in the prescribed form through district administration for registration.
Can you get in touch? No, the one way of doing it is there must be social work organizations in Odisha.
NGOs.
NGOs. Can you identify some who can help us understand what this involves, this entire exercise involves? Even the state government should know.
Yes, my lord. On the last occasion, I think
self-declaration will simply not work in this country.
Nothing at all.
And there are many who are migrants.
And I think that is the only mode of registration, self-declaration.
That won't work, sir. Then always it will be low. The figure will be very low then.
My last, recently, I think they had also involved the PLAs, the paralegal personnel.
Even for them, there must be some guidance note. If they go out into the field, how do they know A is an unorganized labor, B is not? How will they identify?
Yes, there are certain categories given in the act. Certain categories has been extended by the state government to include newspaper hawkers.
So how will they go and identify? I'm just saying the boy studying in school.
Yes,
morning between 3 a.m. and 6 a.m. he's going by cycle and distributing newspapers. then rest of the time he's in school. How will he be identified? And then he's actually child labor, although he's hawking newspapers.
Yes.
Under what category will you put him?
Therefore, I think the
See,
state government.
first of all, there has to be a guidance note. And then these paralegal people themselves will not go and do this enumeration.
Okay.
Not possible.
Not possible. You'll have to have an entire army of people, just like census operations. You have to have an entire army of people doing this and who are oriented for this.
Absolutely.
Before every census operation, they actually call these people, give them training.
Yes, ma'am.
2-3 months
Normally,
training.
school teachers are involved in this.
And then they're actually given training.
They are given training. Yes, my lord. Yes.
The Anganwadi workers.
Anganwadi workers,
Correct.
primary school
So
teachers.
it requires a lot of application of.
No, first of all, we need to understand what it involves. That's why I'm saying you get in touch with some social work organization, you sit with them, have a meeting. They will give you some inputs.
Yeah, maybe United Nations organizations, Action Fair.
Don't go for that level. I'm just saying grassroots here in Orissa.
Yes.
See, the Orissa reality will be different from Bihar, different from West Bengal.
That's so true.
Ah.
Maybe as your lordship said.
And it's seasonal also. See, seasonal. The person who's in Bolangir, he'll be missing for 4 months in the year.
Yes.
He'll be in some other Punjab or he'll be in some other state.
So in view of the magnanimity of the issue, they're saying that only 3 lakhs unorganized is.
Because that's the reason.
That is inadequate.
That is the whole reason.
Is
That's
absolutely.
This, if we want this to improve,
Yes,
you have to find. See, some of this is not adversarial.
absolutely.
It's not that I've placed the problem before you. Now you sit and find a solution. It can't work like that.
Absolutely.
Hmm.
My lord, they have also
May I
submitted
suggest one thing to me, my lords? Your lordship may direct the chief secretary to conduct a meeting, and my learned senior can also assist there. See, because he is representing the public.
No, and also involve some civil
yes.
society organizations.
So she will also be a part of that discussion. The chief secretary will chair the meeting, and labor secretary and labor commissioner, and they will find out some solution guidelines as to how the registration will be made more and more.
Right. You see, one of the issues pointed out in the note submitted by the learned counsel for the petitioner is that the registration of unorganized workers under the Unorganized Workers Social Security Act is low. Is at 3,20,090, which appears to be a very low figure. Full stop. It is pointed out that given the definition of single quotes unorganized worker as including open quotation a home-based worker, self-employed worker, or a wage worker in the unorganized sector, unquote, and not covered by any of the labor welfare legislation, the number must be much higher. Paragraph. It is further pointed out that during the pendency of the present petition, the Parliament has enacted, what is that?
Code on Social Security
The
2020.
Code on Social Security
2020.
2020, which is intended to replace many of the labor welfare legislations by consolidating them into one single COD, C capital code, which also requires to be examined. Full stop. Paragraph. What is not clear is that the mode of registration of unorganized workers. Full stop. If it is by way of single quotes self-declaration, unquote, then expectedly the number is likely to be low. Full stop. If the aforementioned social welfare legislation enacted specifically for unorganized workers has to be effective, then some concerted efforts will have to be made to increase the numbers registered by deploying persons specifically oriented to undertake that exercise by going into the field to meet the unorganized workers where they are presently deployed. Stop. Paragraph. On the suggestion of learned counsel for the parties in the course of hearing, the direction is issued to the Chief Secretary, Government of Orissa, to convene a meeting of all the
Concerned
officers,
officials.
all the concerned senior officials of all the senior officials, the concerned departments who are involved in the implementation of the legislation, with the participation of counsel for the petitioner,
Your Lordship
the
may
secretary,
Your Lordship may name Mrs. Paddy.
Mrs. Paddy, the learned counsel for the petitioner, the secretary of the OSLSA, the Orissa State Legal Service Authority, and at least 3 civil society organizations based in Odisha, which are working for and among unorganized labor, as envisaged unorganized labor. This meeting be convened in the next 30 days to work out the modalities for increasing the coverage of the Act to a whole range of unorganized labor, irrespective of gender, age, and state of origin, who may be working at any given point in time during the year in the state of Orissa. The outcome of these deliberations be recorded and the minutes be placed before this court on the next day. That earlier thing to say, the note also points out that the proposal for issuance of the Social Security Identity Cards, bracket SSIC, and the benefits and the details of the benefit of rupees 2.70 crores stated to have been disbursed. You just say the note also seeks the details from the government regarding the distribution of 1.27 Social Security Identity Cards, bracket SSICs, and the disbursal of rupees 2.70 crores to 270 beneficiaries. Full stop. The meeting of the Chief Secretary will also address the above issues, as well as oversee the working till date of the Single Courts Multi-Agency Monitoring Committee at the district level, headed by the collector, unquote, as indicated in the affidavit of the opposite parties. That is. 6th July.
6th July.
6th July, sir.
Plus, if at the cost of expressing my ignorance, my lord, why is it called the Code of Social Security 2020? Why not an act?
No, this is because it's consolidating several acts.
All others.
Like even the labor code, it's called the labor code because it consolidates.
It's a
Even
huge.
tax, they want to make it a tax code now.
Yes.
Ah.
Thank you.
Supplemental list item number 2.
I'm not permitted, but withdraw.
Correct. This post office withdrawal.
Item number 3. Withdraw.
May I please, Your Lordship? Now, on the last occasion, on the basis of my submission that though the work order and the decision has been taken to develop the playground at a particular plot, which is revealed from the ROR as school ghara and school hata, that means the school building and the school compound, they are making development of this playground at a different place, which is orchard, mango orchard, that is plot number 724 at page 13 and 14 of the brief. On the last occasion, Your Lordship directed my learned senior to take instruction in the matter.
1 week.
Some more time.
I pray, my lord, Your Lordship may kindly fix a short date because there is no interim order. My intention is not that the playground should not be there. My only grievance is it should not be over plot number 724, which is a mango orchard, and it should be in the school compound. But that is there, and that is the allotment. That is their allotment, government's allotment. I am not saying any deviation from that.
Mr. Bharti seeks and is granted 2 more weeks' time to seek instructions. And its request list on 19th April.
Obliged.
Item number 4.
Item 4, Lordship, by flux of time, perhaps Lordship.
Become infructuous, I think.
Election
Yes,
disposed of his instructions. Order.
Item number 5.
May I please your lordships? Here, my lord, the order under challenge, your lordship may see annexure 3, page 97. My lord may kindly see. Has already been settled by your lordship. It starts from 95, annexure 3, but the ordering person is at page 97. Lordship got it, so that I will place it. Yes, may I just place it? The petitioners who are working as Gram Rojgar Sevaks have filed a writ petition seeking to quash the order of transfer under annexure 1 so it relates to the petitioner. The question has already been considered by this court in Manas Kumar Swai so and so, holding that the BDO collector has no authority to transfer any GRS from one place to other. This is not correct. This is only concerning to BDO. I have annexed that. I will show. The second point is, it is stated that the division bench of this court has already stayed the order of transfer passed by the authority in WA number so and so. In view of the above, the order of transfer cannot be effected as the authority has no competence to pass such order. Accordingly, the order of transfer is quashed. But that writ appeal, my lord, a batch of writ petition was heard and when dismissed, filed by the petitioners, holding that the collector has the power to transfer the GRS. Against this, writ appeals have been filed. And your lordship has already held. My lord may kindly see. This is your lordship's judgment. Considering all the facts. Yes. Your lordship may come to page 6 of the that judgment by writ appeal. May I just place para 9 with your lordship's permission?
Yes.
As regards the power of transfer of GRS, a reference is made at para so and so of the operational guidelines which reads as under state government. Responsibility of state government include ensure that full-time dedicated personnel, wherever required, are in place of implementing MG and NREGA, especially the empowered guarantee assessed to Gamrajga Sahayak, the PO and the staff of the said district and class level, delegate financial and administrative powers to the DPC and the program officer as it deemed necessary for the effective implementation of the scheme. Now 10 and 11 is important. In terms of the above guidelines, clear instructions have been issued regarding selection of engagement of GRS on 6th April 2008. Separately, on 2nd June 2018, the government of Odisha has authorized inter alia the collector cum CEO, Jilla Parishad.
This judgment of ours is 19th September.
Yes.
The order impugned is 15th February.
Yes.
So they had, the single judge had
Yes.
no occasion to read this judgment. So
No, my lord, their lordships have held because in this writ appeal, this order has been stayed Therefore, it
Where
is
is that
quashed.
writ appeal order?
Yes,
Where is that order?
yes, that is a page 97. Page 97, which
Sir,
is under
where is
Canada.
the Manas Kumar swine order?
Manas Kumar, yes. That your lordship may kindly see at page 99, annexure 4. Yes,
The
ma'am.
division bench order, sir.
No. This is a single bench order, page 99.
I am asking for the division bench order.
Your lordship's order. No. This Manas Kumar Mahapatra is a single
Sir,
bench.
I'm going to explain to my colleague. He will explain to you.
No.
See, in this. In parrot 2, parrot 3, and parrot.
The stay order passed by the division bench in WA number 402 of 2017.
Yes, that I have given.
Where is that order?
Yeah, we have given to your lordship. Three final judgment has been passed.
Stay order.
3 orders.
This order is 15-2. This order which we have passed is 99.
9. What is
This order cannot be referred to in this single judge's order.
No, the single.
What is that referring to? That order.
That is the stay order of this case.
Where is that?
That matter order. Yes, ma'am. That is, I'm showing. That order he has referred in the repetition. Yes, sir. I'm showing, ma'am. That is there. Yes, your lordship, I'm obliged. Page 40. Your lordship, may kind. I'm just referring.
Standing counsel
Yes.
with all of you.
74. Same.
He's also standing counsel.
Yes,
Yes.
yes.
Why is he coming this side and
Come to this side. ଆପଣ ଏପଟକୁ ଆସନ୍ତୁ ନା, ମୁଁ ସେଇ-
I've never seen him before, so which is why.
No, because I'm in other court.
Ah,
All right.
Come here.
All right. Your lordship, may.
so you'll have to pardon me, sir. My English
Yes,
is
yes,
very
sorry,
poor. My English is very poor.
Sorry.
So sometimes I'm not able to communicate correctly.
Yes, ma'am.
So you have to pardon me, sir.
Yes, ma'am. That your lordship may. Your lordship may come to page 74, annexure 8. That is the writ appeal order. Interim order. In one of the writ appeals, 403. Yes, ma'am. It starts from page 74. 3 writ appeal 403. Same writ appeal. And the ordering portion is page 76. That writ appeal stay order. With judgment, I have handed over to your lordship.
So because of the stay order, the transfer order is to go.
Yes, yes. And your lordship has already decided the collector has the power.
All right. Who is for
But
the
lordship, in fact, lordship, what I submit lordship, because these are the contractual employees lordship.
Yeah.
And a lordship given a landmark judgment also lordship, the collector has absolute power.
Hmm.
We don't have any objection. Let the collector make an assignment, lordship will work. We have no objection, lordship. So it can be disposed of, the collector will be lordship. Assignment work, lordship will work.
So he's agreeing for the impugned order to be set aside.
Yes, ma'am.
And collector to
You see,
give a direction to assign
Mr.
lordship.
Dalai, appearing for the respondents,
Yes.
agrees that in view of the judgment dated 19 September 2022 of the division bench of this court, in writ appeal number 401 of 2017, bracket, Gagan Bihari Patra versus State of Orissa, bracket, the collector has the power to transfer a Gram Rozgar Sevak, bracket GRS. So he adds that the respondents will abide by any order that may be passed by the collector in that regard. Paragraph: in view of the above statement, the impugned order is set aside. The writ appeal is allowed. It will be open now to the collector concerned to issue necessary orders regarding the transfer of the respondents.
Let's grateful.
Deeply.
All right.
I'm sorry, madam.
Appearance of Union of India may kindly put. Here for the open respondent 6.
All right.
Item number 6.
Item number 6, I may permitted to withdraw.
All right.
I'm giving with liberty to file.
File a review. All right.
Item number 7.
Item number 7, that's regard to regularization of DLR employees. The LRC has issued notice and granted interim protection fixed to 25th April. I am giving the transfer.
Same order.
Item 8 and 9, same.
Same order.
Item number 10.
My pleasure, Lordships. Here, my lord, I'm sorry, my lord, I could not able to file that death chart synopsis, my lord. I'm filing just now, my lord. Here, my lord, I have challenged, assailed the order of Honorable Single Judge. It is at, my lord, running page 23, Annex 1, my lord. May place, my lord, the order, my lord. May place.
Yes, please, sir. All permissions granted.
Running
You just carry on and argue the matter now.
23,
Yes.
my lord. Here, my lord, Mr. Dr. Learned Advocate appears on behalf of petitioners and submits intervening added opposite party number 3 has sought to raise dispute. His clients are running the pump pursuant to the interim measure directed by coordinate bench on 21st of January 2015. He submits the oil company OP number 1 and 2 issued improved letter dated 24th of December 2014 requiring reconstitution papers. He draws attention to disclosures in the writ petition to demonstrate that inter alia added opposite party had retired from the partnership. I am added opposite party member. Mr. Patnaik Lawrence Counsel appears on behalf of the oil company on query from court. He submits petitioners are running the pump pursuant to said status quo. In the matter of the running, there has been no occasion till date for his client to find fault for otherwise terminating the license. He submits further, no, your client KYC have to be filed by the whoever runs the pump. That is not been done. Mr. Kanun Golon, senior advocate, appears on behalf of added opposite party and submits his client was minor at the time license was granted. Subsequently, his client was wrongfully removed from the business of running the pump. There should be no interference and the writ petition dismissed. To enable as precondition of renewal of license, settlement of family dispute. It appears improved letter was addressed to the person's legal representatives to whom the license was granted. The order in directing interim measure was passed ex parte against the opposite parties. Opposite parties, including the added opposite parties, let the order subsist. The writ petition has been listed in the instance of court under heading old matters. Apart from the oil company requirement of KYC, the RO is being run to their satisfaction by petitioners pursuant to the order of interim measure. Final family disputes between the petitioners and added opposite parties is of no concern to the oil company. It should be and is interested in its business that has been running presumably to their satisfaction. Interim measures is confirmed. Added opposite party is left found remedy granting family disputes with petitioners, my lord. Here, my lord, I have also annexed the writ petition. What was challenged in the writ petition, my lord? That is at running page, my lord, 51, my lord. Here, my lord, the oil company has issued notice to all the parties. You furnished your reconstitution partnership, my lord. Here, admittedly, the partnership was not reconstituted, has not yet been reconstituted as per law, my lord. When the partnership was constituted, I was minor, my lord. Thereafter, as per law, it has to be reconstituted, but by playing some fraud against me, my lord, the respondent number 1 to 3, my lords, they have managed to proclaim before the BPSL that as if I am resigned from the partnership, my lord. Therefore, as per their BPCL's procedures, they asked.
File a counter affidavit in that writ petition.
Yes, my lord. I have filed counter affidavit. My lord. Yes, my lord. That is, my lord, at running page, my lord, 97, my lord. Here, I have also disclosed the details, my lord. What has happened to my lord, me, my lord. But fact remains, my lord, it is the partnership when, as my lords knows that partnership once when I was inducted in the partnership as minor, and unless it is reconstituted as per law, that still subsists, my lord. Therefore, the BPSL company issued notice that you produce the reconstituted partnership firm. so that we can grant you further renewal of license, my lord. But that was I objected. And my lord, the prayer made in the writ petition to quash that letter issued by the BPCL, wherein the BPCL asked the parties to furnish the reconstituted partnership, my lord. And my lord, on the sole the ground that I had not challenged that interim.
Notice is not gone yet. All right. You say the counsel for the appellant has placed before the court a synopsis as well as a date chart, which has been produced. Say notice returnable.
Obligement.
6 July.
Item 11.
Annex 1 is pending before the collector Kandhamar. The Lordship may direct to dispose it of.
My lord, so far as Annexure 1 is concerned, what I was perusing, my Honorable Justice Satpathy can see, it is in Oriya. The allegations made in that representation is not in conformity with the allegations made in the writ petition. In the representation, they have alleged that one executive engineer, Aniruddha Puhana, at the behest of BJD party leaders, he is trying to suppress some corruption.
No, my
Your
lord.
lordship can read this.
My lord.
And but the
Prayer here is for conclusion of the
My
school.
lord.
this is totally different. Read petition, if your lordship will see the synopsis
My
of the
lord,
case, the read petition is like this. PIL challenging the inaction of the opposite party known to in not taking any steps on their representation data, wherein they have alleged the low-grade construction of the girls' hostel, so and
Yes,
so.
that is there, my lord.
But here is the case is that somebody is doing corruption and somebody is suppressing it.
My lord.
A particular person is named, then that person is to be added as a party. That is
My
my
lord,
only
my
solution.
lord, my sole prayer before your lordship is that a hostel is constructed for the ladies' hostel is constructed for the tribal women. 9 years back, it is not in the habitation mode right now, and taking advantage of it, the antisocials are gathering there. And for
So your
which,
representation should say that. What he's saying is your
My lord,
representation is not saying.
my lord,
Object of the representation.
my lord, along with it, so many other things have been alleged.
Make a fresh representation
Yes,
specific
yes,
to
yes,
this.
In conformity with the averments
Yes,
made in the
yes,
writ
yes,
petition
yes.
only.
It is
That
pointed
will-
out by Mr. Mohanty, learned additional government advocate, that the contents of Annexure 1, which is a representation dated 24th November 2022, made by the petitioners to the collector, Kandaman, is quite different from what is averred in the writ petition, which speaks of the low-grade construction of a girls' hostel meant for the scheduled tribe community. Paragraph. Ms. Jena, learned counsel appearing for the petitioner, states that the petitioners will make a fresh representation to the collector specific to the grievance made in the writ petition. If such representation is made not later than 10th April 2023, then after hearing the petitioners and the persons named in the representation who may be responsible for the low-grade construction, the collector will pass a reasoned order thereon within a period of 3 months thereafter.
Obliged.
And
Alleged
communicate the
low-grade.
order to the
Your lordship may
parties.
say alleged low-grade ones because
alleged. All right.
My lord, obliged, your urgent copy of your lordship's
All
order.
right.
Obliged.
Right.
better this order may be communicated to the collector.
Yeah, copy
Yes.
this order be communicated forth
For
to the collector
compliance.
for compliance.
Item number 12. May please, Your Lordship.
My lord, a village road is being obstructed by the opposite party of 5 by constructing a pakka bathroom on the very village road. And the petitioners are the villagers. And the RI, revenue inspector, is expressing his inability to vacate him. Stating that he is claiming that unless others are removed, other encroachers are removed, I shall not demolish the construction of that pakka bathroom on the road itself. page 16. Page 16, the RI has reported to the Tahsildar that his claims.
Representation is at page 14, annexure 2, to the Tahsildar Khoira.
Yes.
Has it been received by him?
No,
The
there
left
is no
corner.
endorsement
All
of.
right. You say the petitioner's representation, bracket annexure 2, will be examined by the Tahsildar Khaira. And
District Baleshwar. District Baleshwar.
District Baleshwar. And after notice to the petitioners and to opposite party number 5 and giving them a hearing, a reasoned order shall be passed not later than 8th May 23 and be communicated to the parties within a month, within a week thereafter. The court clarifies it as not expressed to you.
Item number 13.
None appears dismissed.
Both the cases. Rate appeal 66 of 2011. Item 14.
Item 14, this is old matters. I pray Lordship call it Thanu captor because file is not available.
Counsel for the appellant states that the file is missing. The appeal is dismissed for non-prosecution with liberty to the appellant to revive the appeal in the event that the file is traced.
Item number 15.
Victim is permitted to withdraw.
Dismissed is withdrawn. All right.
Item number 16.
None appears dismissed.
No, but I am appealing, madam.
Tell us, sir.
Madam, this is a matter I challenge the order of the Honorable Single Judge at page 53. Page 53, madam. The relevant portion is the from the 8th line from the top, madam. The authorities are directed. That's the got it, madam.
Yes.
The authorities are directed to permit the petitioner to appear at the examination to be conducted for future promotion, taking into account his length of service in JMGS from 1/8/92, and also directed to refix the seniority of the petitioner from the date his juniors were promoted with effect from 1/8/92 within a period of 3 months. And then Lordship, can it turn to page 8? Page 7, madam.
So this order is 1st December 2014.
Yes, madam. I filed this 2015, 24 days delay, madam. I filed in this case also.
No. Was there a stay granted by this court?
No, madam. I don't think so.
Then you must have implemented the order.
That I have no instruction because the old matter, 15 matters, has already immediately listed.
Then it's all infractuous, sir. There has been no stay of the impugned order, which gave time-bound directions to the appellant to comply with its directions. There was, in that view of the matter, the impugned directions also have been complied with by now, rendering the appeal itself infructuous. It is disposed of as such.
Item number 17.
My name may be recorded, madam.
Yes, please. Yes, please.
Item 17.
None appears dismissed.
Item number 18.
None appears dismissed.
Item number 19.
None appears dismissed.
Item number 20.
None appears dismissed.
Item 21.
In item 21, respond number 2 and 3 are state comment. And let him serve a copy to me. I will take instruction.
What's the matter?
I'll share in course of day. Because here is, my lord, the enhancement is 58 to 60, my lord. The Honorable Single Judge has passed an order, my lord, rejecting my writ petition, my lord, on the ground, my lord, the Sarat Chandra Tripathi case, my lord, is applicable to my case. But here is a case, my lord. This case is not applicable to my case. And review petition also been dismissed. Therefore, I come before my lord.
So you not had this matter listed for all these years.
My lord. In course of
It has not even come up once, sir.
My lord. In course of that, I'll sort the copy to the government as well as, my lord, Odisha Housing Board. Your lordship fix up another paper for hearing, my lord.
No. Let's see what the matter is about.
My lord. Here, my lord, lordship may kindly see, my lord, the order dated, your lordship, my lord, 25/8/2015, passed by the Honorable Single Judge, my lord, where it has been observed, page 53. Lordship may kindly see.
No, you wanted to have your retirement age enhanced.
Yes, my lord. That lordship has already been decided, your lordship's judgment, my lord, because here, my lord, the Sarat Chandra Tripathi case, my lord, it is a own set of rule, my lord. Here is my lord, the government rule. We are governed under the government rule, my lord.
You're a state housing board, sir.
A housing board, my lord.
For housing board was a resolution increasing retirement age.
Yes, my lord. Resolution has passed, and also, my lord.
When was it passed, sir?
My lord, it's a 2014, my lord. So, lordship,
when did you retire?
30/11/2014, my lords. Yes, page number 45, annexure 4, my lords. So prior to that, my lord.
No, let's come to page 52, that quoted
52. Yes, my lord. 52. Lordship. Lordship, may I permitted to place, my lord?
I am asking you to place.
Yes. Yes, Lordship. Lordship. That, my lord, heard operative heard Mr. A. Daslane, counsel for the petitioner, Mr. D. Mohapatlan, counsel for the opposite partner 1. The petitioner has filed this application for enhancement of his retirement is for 58 years to 60 years. So far as the Odisha State Housing Board employees are concerned. Mr. A. Daslane, counsel for the petitioner, submitted that the petition is entitled to get the benefit of retirement of age from 58 years to 60 years in view of the resolution passed by the government of Odisha on 28/6/2014 under Annexure 1. But the said benefit has not been granted to the petitioner. Therefore, the petitioner has approached this court by filing this application. Mr. D. Mohapatral and a counsel for the opposite partner 1 refers to paragraph 9 of the counter affidavit, which are reads as follows, my lord. That counter affidavit paragraph 9, it was been reflected that the reply to averment made in paragraph from 13 to 16 of the writ petition, the opposite party submits that the representation of the petitioner under Annexure 5, as stated in paragraph 13 of the writ petition regarding prayer for postpone the operation of the order issued under Annexure 4 and allow him to continue in service still attaining the age of 60 years, as for the statutory provision and citing the rule 5 subsection 3 of the OHB rule 1970, etc. No final decision has been taken in this regard. And as for the decision of the 269th board meeting held on 21/10/2014, a committee has been framed in this regard, and report of the committee will be submitted in the next board meeting, except the contention referred to above. All other contentions in those paragraphs of the writ application which are not specifically admitted are deemed to be have been denied. However, in this meantime, the petitioner has already been relieved from board service on 30/11/2014 afternoon on attaining the superannuation age of 58 years communicated by OSHB letter number 14581 dated 29/11/2014, board meeting agenda and proceeding, as well as an office letter issued in this regard on dated 12/11/2014 to the committee and report compliance along with superannuation letter of OSHB dated 29/11/2014 are annexed to the annexure.
What do you have to say to this?
My lord, lastly, my lord, before that, my lord, lordship, the other employees, lordship, other employees is concerned, the same Odisha State Housing Board passed a resolution for enhancing the age of 58 to 60 years, my lord, the dated 4 July 2014, prior to retirement of the petitioner. But petitioner age was not been enhanced. So lordship may permitted to place this order, my lord. Today morning I got it, my lord. Therefore, I unable to file an affidavit.
You file. Mr. Constable, the appellant wants to place some other documents on record along with an affidavit. Please permitted to do so before the next date.
Lordship.
Grateful. 3rd July.
Lordship. Grateful.
Item number 22. Item 22.
None appears dismissed.
Item number 23.
Item 23, my lord, there is a delay of about 120 days. That apart, the licensee challenge the said same order. The lordship has disposed of the writ appeal, leaving the question of law only.
The impugned order has already been affirmed by this court. by an order dated 10/10/2022 in writ appeal number 150 of 2016. The present appeal is accordingly dismissed.
Question of law.
The question of law, however, is left open for decision in some other case. All right.
Item number 24.
You are for the respondent.
Madam for the respondent.
None appears for the appellant. Dismissal not possible.
Item 25.
None appears dismissed.
Item number 26.
Same.
Item 26, my lord, this is covered by your lordship's judgment rendered in the writ appeal batch, my lord, the transport matter. Challenging that circular issued by the Transport Commission, my lord.
In view of the judgment of this court, what has happened? This has not been challenged to the Supreme Court yet.
No, my lord, not yet. As per my
In view of the
instructions.
judgment dated 21st December 2022. It's not reported anywhere also.
As of now.
In writ appeal number 163 of 2017. Bracket Messrs. Sushri Automotives versus State of Orissa. The present writ appeal is allowed and the impugned order is set aside.
Highly obliged.
Item 27.
In the same terms.
Item number 27.
None appears dismissed.
Item number 28.
My lord, in item number 27, we are for the Union of India.
All right. So none appears to the appellant dismissed. 28.
28.
None appears for the appellant dismissed.
Item 29.
May I please, Your Lordship?
Yes.
One of the petitioner challenge, the appellant challenges order of Honorable Single Judge at page 31 at Annexure 5, Your Lordship. Your Lordship may peruse para 6, wherein Honorable Single Judge has dismissed the writ petition considering the fact that the present appellant has not described any particulars in the application form grant of residence certificate. And the if Your Lordship peruse section 4 of rule 4 of Odisha miscellaneous certificate rules 1984, that has not provided for information to provide any information at the time of application, my lord. The mandate says section rule 4 application for miscellaneous certificate. A person desirous to obtain a certificate shall file before the revenue officer an application in form 1 affixing court fee stamp of the denomination of ₹3 or such amount as should be revised from time to time, specifying therein his name and full address, the nature of the certificate paid for, and the purpose for which it is required. This is the mandate, my lord. This fourth thing has to be given in the application form. And moreover, the residence certificate has been declined by the OP number 4, respondent number 4. The respondent number 4 has filed counter affidavit in the writ application admitting the fact that there was some clerical error in para 8, 9 and 10 of the counter affidavit. They admitted that there is a clerical error made by the RI to put the khata number and plot number in the inquiry report, my lord. If Your Lordship peruse the counter of respondent number 2 in para 8.
Is there a debate? No. All right. You just say notice, he accepts notice for opposite parties. Respondent numbers 1 to 3. Notice will now go to respondent number 4, the registered speed post returnable on the next day. 10th July.
Item number 30.
Your Lordship, interim application is there, my lord.
Notice on that also. All right.
Obliged, Your Lordship.
My lord is fixing date.
10th July. Sir. Item 30.
None appears dismissed.
Item number 31.
None appears dismissed.
Item number 32.
32, my lord. Here,
This arises out of a consolidation proceeding, my lord. I am a list pendant purchaser, my lord. My vendor has filed a writ appeal against the judgment of the single bench, my lord. That is writ appeal number 543 of 2022. That has been dismissed for default on 27th October 2022. And in the meantime, he has filed a CMAPL, wherein CMAPL number 593 of 2022. What I pray, my lord, I will pursue this writ appeal after the CMPL is the
All right, the request comes to the appellant list on 10th July.
at note 33.
On behalf of Mr. Mantri, my lord, delay of 10 days, my lord. Copy already served, my lord, arising out of a sealing case. 10 days delay, my lord. Maybe condoned.
Carry on. What is the
So,
appeal?
my lord, Mr. Mantri likes in court number 20, my lord. If your lordship may pass it over.
Then first pass over. Take out that order. Pass over.
Right. Item 34.
My lordship, on behalf of Mr. B.K. Das, item number 34 and 35 kindly pass over, my lord.
All right.
Item 36.
Lord, Sarat Corridor case.
8 May.
8-5.
Item 37.
Hey, please, your lordship, my lord.
Yes.
I am on VC, my lord.
Yes.
As per earlier order, I have undertaken to file the certified copy of the input judgment. As my grandmother expert in the meantime, I could not file. Your lordship to give another opportunity.
All right. List on 10 July. Defects be cured in the meanwhile.
At note 38.
I am OP5 on behalf of OP5 on VC.
38, sir.
If your lordship will not inconvenience, 34.
We'll just do 38, sir.
Sorry. In item 38, may I pray your lordship call this matter day after tomorrow, so that on last occasion your lordship has given me to take instruction regarding the status of that recruitment process.
And they have admitted in the counter lordship that the person of direction of this honorable court, they have cancelled the because that person did not qualify. Now, lordship, only point to be decided, lordship, I have not made party in the writ application. I am a selectee under the 2016 selection procedure, lordship. The respondent had challenged the 2012 selection procedure, and while considering his writ application, without making me party, that subsequent advertisement has been quashed. I have not made party in that writ application, lordship. So only I pray, lordship, let it be hard, lordship.
So you have not made that person a party?
Yes, I have made party, lordship.
Have they been served?
I have made party, her party, lordship.
Notice issued, I have appeared.
Lordship.
From
Mr. Nanda is appearing, lordship. He is in BC.
Don't have a copy?
Yes, lordship, I have soft copy.
Last occasion, my friend has served a copy. And in the first advertisement, the present appellant, he was not there. I was selected. Then when the selection process did not continue, I came before this honorable court by filing a writ application number.
No, but you were to take, Mr. Kuntia, you were to take instructions.
Yes, that I am praying.
Mr. Kuntia needs some more time for instructions. At his request, list on 12 July.
Obliged.
Yes, Mr.
Interim to continue, lordship.
All right, interim order to continue. Yes, Mr. Dash.
34.
I'm obliged, my lord. 34 item of happened, my lord. 2 defects are there. Already the defects are not been removed. What happened, my lordship can also dispose of this matter in final year. What happened in this particular matter? I am appearing for Orissa Renewable Energy and Development Agencies. That is the grievances with regard to age relaxation, that is 60 years, whether they will continue or not. In the series of cases, batch of cases, lordship dispose of, already dispose of. This matter, 2 matters are covered by this judgment. So in terms of this judgment, lordship can be disposed. I would take.
You see, in view of the judgment dated 22nd November 2021, passed by this court in WA number 306 of 2017, bracket, Chief Executive Odisha Renewable Energy Development Agency versus Krishna Chandra Maharana. The present appeals are also disposed of the same terms. I'm grateful, man. Right.
35.
Yeah. Both put together. Similar, madam.
Item number 39.
Item 39, my lord. Not pressed, my lord. Item 30. Disposed of is not pressed.
Item number 40. 40, I may permitted to withdraw with liberty to file a review.
Review. Or
item 41.
41 is same, man.
Or
item 40 as item 40.
Or
item 42. 42 also same.
Same.
In item 41 and 42, my appearance may be kindly be noted.
Yes.
And a batch of writ appeals are already pending. Can I give a list of that?
Yes. Take it on board and same order.
Yes, sir.
You better give him this list because.
Yes, your lordship. I'll give a list.
Take it on board, same order.
I'm grateful, your lordship.
Item 43.
None appears dismissed.
Item number 44. May I please? My input order is sorry, my lord. Input order is at page 14, my lord. What has happened in this case, my lord? His height was wrongly recorded as 179.3. Subsequently, it was detected 169.3. So for my lord, 179.3, he was awarded 18 marks. And when it was found that 169, he was awarded 12 marks. So after deduction of 6 marks, he could not come to the within the zone of consideration. And the last man has secured 51.75 marks.
No. If 6 marks is reduced from him,
that has been wrongly recorded. It has been recorded as 59. The Honorable Single Judge has recorded it 59. In fact, he has secured 55.63 marks.
Oh, why didn't you file a review petition then?
That was the before the counter. Also, that was the counter before.
It's a review. Yeah, classic case for review, sir, because the single judge notes that his total marks comes to 52.
Yes, ma'am. I have given that marks.
So you file a review, sir. Counsel with the petitioner. The appellant seek leave to withdraw the present appeal with liberty to file a review petition. Since according to the appellant, the marks actually secured by the respondent was
55.63.
55.63
after deduction.
And after deduction of 6 marks, it would come to 49.63. Whereas the judgment in review understands it to be 51.75. Dispose of is withdrawn with liberty is paid for.
Item number 45. None
appears dismissed.
Item number 46.
46 is Sarath Paranamar, 85.
47. Item number 47.
47 is same as item 7, ma'am.
All right.
Item 7 of 2 days list.
Right. 48.
Same.
48 and 49 both are Sarath Parada 285, ma'am.
Right.
Item 50.
50 is also Sarath Parada.
Sarath
85.
All right. 85.
Item 51.
51 is same as item number 7, ma'am.
All right.
DLR. 25th April.
Regulation DL.
Right.
Item 52.
52 is Sarath Parada.
Right.
85.
Right.
Item number 53.
53 is regulation DL, my lord. Same as item 7.
Right.
Item number 54.
May I please, your lordship, my lord?
The writ petition was filed challenging the retirement age from the age of 60 to 65 years, my lord. The petitioner was working in the recognized honorary degree college, whereas in the resolution it was decided that the age can be increased from 60 to 65, my lord. Similarly, similar situated employees also in the honorary college are also continuing in the same manner, availing the superannuation has increased from 60 to 65 years, and also with the salary being increased by a rate of 15%, my lord. Well, the Honorable Judge was dismissing the writ petition. Impugnator held that the governing body cannot decide the age of retirement of the employees unilaterally without the approval of the government. But in fact, in respect of private honorary governing body, it is competent to formulate such condition of the employees, my lord. That is what I'm holding out.
No, what are you? You are an aided body, right?
My lord. Private unaided college, my lord.
You're private unaided?
My
lord. No, but how does the retirement age increase then?
My lord, they can formulate such conditions that they can increase the age without the approval of the government, my lord.
No, but have they? The can is one thing, but have they actually done it? The court cannot issue a mandamus for that.
My lord, I will take instruction on that.
No, nothing for instruction, sir. The challenge the present appeal is to an order dated 15 February 2022, passed by the learned single judge, dismissing the appellant's writ petition civil 32896 of 2022. The contention of the present appellant before the learned single judge was that he ought not to be retired on completion of the age of 58 and should have been continued till he completed, from age of 60, and should be continued as a non-teaching staff till 65 years. Paragraph. According to the appellant, he works in a private unaided college and therefore is not governed by the statute, rules and regulations of the Department of Higher Education, Orissa, in terms of which the governing body cannot decide on the enhancement of retirement age unilaterally without approval of the government. Paragraph. The date of birth of the petitioner was 10th April 1961, and therefore he completed 60 years, and his date of retirement was 30th April 2021. Full stop. There cannot be any mandamus issued to a private college that it should increase its retirement age. Full stop. This is a decision to be taken by the governing body of such college itself. Full stop. With the governing body not having decided on increasing the age of retirement at the time when the appellant retired, the decision of the learned single judge cannot be faulted. The writ appeal is accordingly dismissed.
Item number 55.
No, 55, 56, and 57. Regulation matter same as item 7.
Same as 7.
Item number 58.
58, my lord's order was challenged before the Honorable Apex Court, and that has been confirmed.
I'm passing over to Anna.
The order dated 18th April 2022 passed by this court, interpretation civil 26692 of 2011, stands affirmed by the Supreme Court by its order dated 10th October 2022 in SLP Civil Diary number 22626 of 2022. That way the matter, the present writ appeal is dismissed.
59 also same.
59, my lord, same. In this case, my name may require, my lord, also direct them to comply the order.
That now you will have contempt and all that.
Contempt, my lord, they have been retiring since 20 years, 15 years back.
It's all right.
Your lordship will ask them to comply to
that. Is forthwith compliable, sir. Yes.
Item 60.
60 and 61, same. Item 7, man.
As 7. All right.
61.
Both.
Item 62.
May I please, the petitioner filed the writ application with the prayer to declare the disciplinary proceeding initiated way back in 2011 to be stale and lapsed after my superannuation on March 2019. But my writ application came to virtually dismissed by directing the disciplinary authority to conclude the proceeding within a period of 6 months. A direct point, the issue which is I'm raising, that is
But that 6 months is also over now.
That is also they know that they don't have any authority.
No, but it's over. That 6 months is over now.
But my dues have not been paid.
That is a separate cause of action then.
The reason for not being paying me.
No, but there's no reason to interfere with the impugned order.
No, the direction
if
is
they have not complied with the impugned order itself, how does it hurt you?
The
impugned order asks them to complete it in 6 months. They have not completed in 6 months.
They neither initiated nor processed.
So
since 2011.
So how does this order work against you?
Because of the pendency of this proceeding, they are withholding my retired dues.
No. You say the impugned order merely requires. Just listen. The impugned order requires the respondent state cooperative bank to complete the disciplinary inquiry against the appellant within 6 months from the date of that order. Full stop. Admittedly, the 6 months period is already concluded on
January 23.
In January 2023. And yet till date, there has been not even an initiation of the disciplinary inquiry. So in that way, the impugned order has already worked itself out and is no longer prejudicial to the present appellant. Paragraph. It will be now open to the appellant to again approach the respondents for release of his
service and retirement benefits.
Service and retirement benefits in accordance with law, and upon the failure of the respondents to accede to that request, to seek appropriate remedies in accordance with law. The writ appeal is disposed of in the above terms.
Do you understand the time frame?
Say that, please. Yeah.
Item number 63. 63.
My lord, item number 63. And there are some defects which needs to be removed, and we need to take some instructions from the client. So,
what's the matter about?
It's about an Anganwadi matter which was dismissed on date. 1 minute. My lord, it was relating to WPC number 15,248 of 2017, my lord. We have come against the order passed in the date of 31/5/2017.
What is wrong with the impugned order?
And my senior should argue.
We'll pass it over. Pass over.
Item 64.
Please to your lordship, my lord. This is the order, my lord, impact order. I am against that, my lord. Page 28 of the brief. Thus, the honorable single bench only on the ground rejected that in the gift deed. My father has not mentioned anything regarding the to give appointment to the any son of my father. That is the only thing. The case is that, my lord, in the hand, my lord. Because for the opening of the public health center in the particular village, my lord, there is no government land in that village. So my father donated the land to the health department for opening of that center, my lord. Accordingly, my lord, the procedure was made, and thereafter the center was constructed. In the meanwhile, I applied for appointment as I am the son of the donor. I applied to appoint me any post in the health department. According to that, my lord, my application was forwarded by Annexure 6, page 21 by the CDMO to the Principal Secretary Health to give issue necessary instruction, page 21, Annex 6, my lord.
Yes.
To issue necessary instruction regarding engagement of Ananda Saraf, that is the petitioner, for land of construction sub-center at village under HCSC, my lord. Thereafter, my lord, the villagers submitted one grievance application before the authority that there is some difficulty arises on the question that the son of the donor has now demanding for the appointment. So the villagers forwarded the letter to the department that to solve the matter by, if possible, to engage the petitioner, my lord. It was forwarded, but again the CDMO rejected my application, so I came before your lordship, my lord. I filed the writ application, but in the writ application, the honorable single judge said in the page 20 that there is no line, the single word in the gift deed that to in future to give appointment to any of the successor. So that the writ application, my lord, they dismissed, my lord. So I came before your lordship, my lord. It is not a, so according to that gift deed, my lord, I have no case at all, my lord. Only it is a question of mercy, my lord.
Because mercy.
Because
you've only been delegated to a
my lord, 2 acres of valuable land, my father only donated to the health department.
Yes.
So it is my humble prayer before the honorable in the particular department by the petitioner.
Yes.
As he is now in the poor condition.
That's all right.
He has no money
mandamus could have been issued to the opposite parties to employ.
May I submit one thing, my lord? Liberty to, I will approach again to the authority.
That's up to you, sir. Counsel for the appellant does not wish to press the writ appeal, but reserves the right to approach the authorities again in accordance with law, without commenting in any way on the merits of the contentions of the appellant. The appeal is disposed of as withdrawn with liberty is paid for.
Item number 65.
You are appearing?
Your Lordship,
Ah.
appearing. 65. Your Lordship, the common ancestor of this appellant was the ex-ruler of one Kalinga estate. The arrower in respect of 22 numbers of plots at the page 23 annexure 1 was recorded in his name. And its last publication was 23rd November.
Same order, sir. Same. It's a 15B order.
15B order. But we have not
there's
been
no
given
appeal
an
against that. There's
No,
no.
we have, your Lordship, kindly see that cost title was they have filed in that RP case. We have not been made a party there.
You can file a civil suit for that, sir.
That's right, but this order is operating against me. Let it be decided.
File a suit and in that seek an injunction.
I must be hard, Your Lordship, in this matter. Kindly go to page 15 to provision, Your Lordship. Please go to. Now the provision what said that provided that no such direction shall be made until reasonable opportunity has been given to the parties concerned to appear and add.
So if you are agreed with that order, the remedy is by a civil suit.
But why is it this order is operating against me? On the strength of this order, Your Lordship,
the civil
they
suit
have
you can ask for interim relief, sir. In the civil suit, you can ask for interim relief.
These people, these private respondents before Lordship, they were never in possession, not in adverse possession. Kindly see the annexure 1, Your Lordship, they are nowhere there.
All right.
They are altogether foreigners to this.
Relegates the appellant to the civil court for any grievance that the appellant may have against the order, the revisional order passed under section 15 small b of the Orissa Survey and Settlement Act 1958. Paragraph. Having heard learned counsel of the appellant, the court sees no error committed by the learned single judge in the impugned order. So stop. There's no merit in the present appeal. It's dismissed as such.
Item 66.
May I please, my lord, in this case, the petitioner challenged the order dated 26/8/2022 passed by the learned single judge had annexure 1, my lord. That is running page 12 onwards, my lord. In para 6 of the said judgment, the honorable single judge has been pleased to direct that to deposit 50% of the total loan outstanding So the vehicle was seized on dated 6/8/2022. At that time, he had only 8 defaulted EMI. The loan,
The impute order balances out, requires you to pay 50% and take possession of the vehicle.
My honorable single judge has stated the total loan outstanding. My loan is up to 2025, but I had only defaulted 6 to.
I know you may have defaulted only in some installments, but what you are required to now pay.
I am ready to pay the total outstanding which is against me. What is against me?
No, on 50% itself you're getting the vehicle. Just come to para 6.
My lord. In view of the above submission, learned counsel for the petitioner, the court taking into consideration the fact that the petitioner earning his livelihood from the vehicle bearing registration number so and so, as well as pandemic COVID, this court dispose of the writ petition with a direction that in the event of petitioner deposit 50% of the total outstanding loan dues on date within a period of 4 weeks. Hence, the vehicle in question shall be released. The petitioner shall file undertaking to the opposite party number 2 to pay monthly installment.
So you're getting the vehicle released if you deposit 50%.
My lord, I had gone to the opposite parties with a bank draft of 2 lakhs rupees, 2 lakhs. I have also annexed, that is, my lord, kindly have a glance to
But why should we interfere in appeal? This order is not against you.
The company, then I had filed a IA for modification of that order, as the company is not releasing my vehicle.
Anyway, that application is before the single judge.
Yes, I had
You
filed
pursue that, sir. You pursue that.
No, I had filed an IA. I have also annexed that order IA. In that IA, the honorable single judge stated that that is running page 20, my lord. That is an application for modification of order dated 26 August 2022, which is writ petition is disposed of. Lord and counsel for the petitioner submit that though the petitioner had approached the authority with 50% of the outstanding dues, drawing a bank draft in favor of the financier, but they did not accept the same. On the other hand, they are demanding 50% of the entire loan amount till 2025.
That you have to actually either seek clarification with the single judge.
I had approached the honorable single judge with that IA for modification and clarification.
Yes.
But the company next para, learned counsel for the financier submit that the same is a blatant lie. The petitioner has never approached the financier seeking for details outstanding dues observed in paragraph 6 in the order dated 26 of August 2022. But while the company has not, notice was not issued and the company lawyer has not filed wakalatnama, at that time he submitted that and learned single judge.
Did you approach them or not? Clearly says it, they have not, you've not.
He has not filed wakalatnama, but I had given affidavit and also given the bank draft of 2 lakhs rupees, which was annexed to that IA.
Yes.
And running page 42, they have stated their outstanding, and my running page 43, my letter, and running page 44 is bank draft of 2 lakh rupees.
Fine, sir. The challenge in the present writ appeal is to 2 orders. The first being 26th August 2022, passed by the Learned Single Judge in writ petition civil 21670 of 2022, directing that subject to the appellant depositing 50% of the single court's total outstanding loan dues as on date within a period of 4 weeks hence, the vehicle in question shall be released. Full stop, unquote. Paragraph, counsel the appellant points out that seeking further clarification of the above order, the appellant had filed IA number 12341 of 2022, seeking modification of the above order dated 26 August 2022, disposing of the writ petition. Full stop. The grievance was that the bank is demanding 50% of the entire loan amount, whereas what the appellant was offering to pay is 50% of the outstanding dues. Full stop. The learned single judge could not find any material to show that the appellant had in fact approached the financier regarding his outstanding dues. Paragraph. Having heard learned counsel for the appellate, the court finds no reason to modify, to interfere with either the order dated 26 August 2022 or the subsequent order dated 22nd September 2022 passed by the learned single judge. Full stop. It was clearly a conditional interim order. It was a conditional order regarding release of the subject to which the vehicle in question was to be released to the appellant. Full stop. The order itself is very clear that the appellant had to deposit, open quotation, 50% of the total outstanding loan dues as on due date, unquote. So there's no need to seek further modification or clarification about what the above expression meant. Paragraph. The court finds no reason to interfere with the impugned orders. The writ appeal is dismissed.
Item number 67.
Page 76 in the impugned order. On the same issue, your lordship has fixed another matter to on 4/4/2013,
All right.
23,
List on 4/4/23.
along with WA number 1296 of 2022.
1296 of 22. All right.
No, 68.
May I please, your lordship? Since I am affected in the Horpex, my lord, I could not appear physically. I am appearing on VC, my lord. And noting is that, my lord, delay petition, condemnation petition not filed. My associate is there, is filing delay condemnation petition for 3 days delay in filing the writ appeal, my lord.
What is wrong with the impugned order?
My lord, in page 194, the Honorable Single Judge held that petitioner received granted after 1489 cut-off date and is not eligible to use his scale of pay. In similar case, Honorable Supreme Court in Ashwini Das case and Mamata Mahanti case has held that cut-off date relating to grant of recognition for degree and those colleges received recognition and affiliation much prior to 1489 is entitled to UGC scale of pay. And even though the petitioner placed the said fact and the judgment of this Honorable Court before the Honorable Single Judge held that petition not entitled to UGC scale. Besides, my lords, in page 195 and 199 of the impugned judgment, Honorable Single Judge held that applicability of the resolution letter 6/11/90 in case of teachers who were not considered or eligible to be covered under a direct payment scheme prior to cut-off date was not issued in the Mamata Mahanti case. My respectful submission that the said case was relating to applicability of 6/11/90 resolution was considered both in Mamata Mahanti case and Ashwini Das case by the Apex Court, and thereafter government extended UG scale of pay to the teachers. In the instant case, my lord, the government extended UG scale of pay to teachers to underqualified teachers, and after getting PhD and MPhil. In the instance case, the appellant having first division 63% marks in postgraduate and before appointment having completed MPhil and after appointment having done PhD has been denied UG scale of pay on flimsy ground that cut-off date. So many writ petition allowed and Supreme Court upheld their cases, and so many cases they have extended UG scale of pay. In the instant case, my lord, the petitioner college, Indira Gandhi Women's College, in which the appellant was appointed, has got government concurrence and affiliation for +3 degree much prior to 1489. Therefore, the college is covered under UG scale of pay.
But why did you wait till 2005 to approach?
My lord, your lordship rightly point out in 1997, my post was approved. But the Honorable Single Judge wrongly held that in 89 and 90 I could have approached. After approval of my post in 97, I approached in 2005, filed several representations.
So why did you wait for 8 years?
My lord, I have made several representations, my lord.
No. 8 years, after 8 years, you started making representations.
No, your lordship, in page 177, Honorable Single Judge held that I have made several representation. Page 177
Yes,
of the impugned judgment, my lord.
yes.
And in my lord, in other case, those other case they have approached my lord after 10 years and 20 years of approval of their post. And in Mamata Manti case, the Honorable Appellate Court directed to the government to consider their cases. And after considering, government extended UG scale of pay to underqualified lecturers, even though the appellant who was qualified having PhD and MPhil degree was denied UG scale of pay. And in very college, my lord, first post, third post, I am holding second post. First post and second
All right,
post.
all right. Notice on both appeal and application for condemnation of delay. Returnable. 22nd August.
Item 69.
Today is filed.
69.
May it please, my lord. Non-grant of pension to the petitioner who is a retired professor in law. That was challenged, and first he came, and thereafter, my lord, the Honorable Court said that you have to make a representation. He made a representation, and when the representation was not accepted, he appeared in the second case, and that after that being this is challenged, the order has come against him. That is a defect, my lord. The copy has not been served. That is sold to the state. I will serve the copy in the course of the day, so that the.
All right. You say list on. April, defects be cured in the meanwhile.
Note 70.
The order, my lord, also turn to page 57, my lord. 57. The earlier writ petition was filed in 2016, was disposed of with liberty given to the petitioner to file afresh if any cause of action still subsists, my lord. Then since cause of action subsisting, my lord, second file the writ petition 30641, lordship turn to page 59, the order of the Honorable Single Judge, my lord. In fact, matter was not assigned, still Honorable Single Judge dismissed, since cause of action of 2015, and even if it approached earlier, it didn't.
What's the ground for delay? What is the explanation for the delay?
My lord, your lordship turn to page 57, my lord.
Yes.
57. I had earlier approached, my lord. There is liberty of the single judge to file the writ petition, my lord. Page 57, paragraph 3, my lord. There was no delay at all. I was filed the writ petition in 2016, my lord.
All right. It is seen from the impugned order that it has been, the writ petition has been dismissed only on the ground of delay. Whereas the delay, by noting that the appellant had challenged an order dated 10th September 2015 only on 14 November 2022, paragraph. However, what was perhaps overlooked was the fact that the aforementioned order was in fact challenged in 2016 itself by filing OA number 1943 bracket C of 2016 before the Orissa Administrative Tribunal, which writ petition was in fact transferred to the High Court and disposed of only on 8th August 2022, granting liberty to the appellant to file a fresh petition, open quotation, if any cause of action still subsists, unquote. It is pursuant to the above liberty that the fresh writ petition was filed. Stop. Therefore, clearly, the writ petition could not have been dismissed on the ground of laches. Paragraph. In that view of the matter, the impugned order is set aside and writ petition civil 30641 of 2022 is restored to the file of the learned single judge, where it will be listed for hearing on 3rd July 2023. No, we'll see. It will be listed in the roster bench, where it will be listed for hearing on 24th April 2023.
Item 71.
The writ appeal is disposed of the above terms.
My lords, be pleased. At first, I want to thank the honorable bench for allowing me to have access over the soft copy of the brief.
All right.
My lord, this case was filed in September 2015, challenging the license, the grant license for on-shop to operate in SCR plot number 59 in Kharwal Nagar, my lord. My lord, the notice was issued. All the opposite parties have filed the reply. My lord, the only reply from the...
Which item are you appearing in, sir?
My lord, 71.
71 is something else. This
Writ
is
appeal 7 of 2023.
Oh, no.
Item 71. Call it out.
Item 71, WS 7 of 2023.
All right, pass over.
Item 72.
72, I have given that order, my lord, that regulation was super then.
All right, same one.
To 14.9. 77, my lord.
Item 73.
73, my lord, Sarat Parida, 8.5.
8.5.
Item 74.
Same as 72, my lord.
All right.
Item 75.
75 is same as 72, my lord.
All right.
Obliged.
Item 76.
76, in fact, that resolution plan, my lord, they didn't prefer any claim relating to it, almost covered by your several decisions of
this
your
case,
lord.
I am supposed to file the counter affidavit. The draft is ready. Take last chance.
Must be covered by that Ghanshyam Mishra.
Ghanshyam Mishra, then
No, I will take instruction, my lord. This is the very huge
then, my
demand.
lord,
Huge
two
demand
judgments
is
of-
there and interim order is there. Stay.
All right. Last opportunity to the
Yes.
opposite parties to file a reply within 8 weeks. Rejoined for the next date. Interim order to continue. List on 31st August.
Well, can it be prior to that? Well,
Interim order is there, sir.
It will be over in 2 minutes. my
I
lord.
know.
It is squarely covered by your lordship's decision. And two decisions of your lordship's, my lord. Baleswar Ferraris and Bhushan Steel.
Correct. Next year it will happen.
Let it come in July at least.
All right, so doesn't make it. Whoever is read it will apply it. So
Item 77.
Interim order. my lord.
continue.
Yes, that is.
Item number 77.
My lords, be pleased. My lord, sorry for causing
No, it's all right.
inconvenience.
Tell us. What is
My
that?
lord, this PIL was filed in September 2015, challenging the granting of on-shop liquor license for operating Maharani Bar in the SCR plot number 59 of Kharwal Nagar. My lord, in this case, the notice was issued. All the opposite parties have filed the reply except opposite party number 1.
On-shop license is valid for how many years?
My lord,
No, this is
it's-
forever.
Ever is
Even
it?
if it is inheritable also.
So how it's now that on-shop has been working for
My lord.
It's an old on-shop in Bhubaneswar.
My lord, I have you some. My lord, I request my lords to have one document. In 2016, the GA department had issued one notice to close the on-shop, and my lord, no action has been taken after that. When my lord, I want.
What is
I
the subsisting cause of action? Tell us.
My lord, we are in the process of procuring the new license that they have got, but we don't have it. But my
File
lord,
a fresh petition if you're able to get it.
my lord, but this has been pending. At least a reply from the GA department would solve. My lord, they have already issued. I request my lord to see at least this document, the closure letter.
That's all over, sir. 2016 letter.
My lord, but still the license that is granted, my lord, there is no annexure present in the document which would show that they have spoken to the GA department. My lord, there is no communication made between excise department and the GA department. And my lord, it is there in the
Licensing
document.
authority has filed the counter affidavit. And it is in para 3, your lordship may see that there is another on-shop within 100 meters distance from this Maharani Bar, and he is not objecting that. So the very stand we have taken.
Selective challenge.
Say yes, madam.
My lord, then why the GA department issued this letter particularly for Maharani Bar in 2016?
Yes.
And my lord, why then excise department never consulted with GA department prior to granting of the license, my lord? But there is a big question. I just request my lord to answer this, get the answer from this question.
They filed enough counter affidavits, sir. There are 3-4 counter affidavits for each opposite party.
My lord, but the land belongs to GA department and they have not filed their reply.
It's all right. Sir,
But rather they have issued a letter for closure of the on-shop.
Yes. Have you filed a rejoinder to this counter affidavit
Indeed,
of
my lord,
party
but
for 5?
Filed the rejoinder for OP number 2 to OP number 5.
Yes.
My lord, but the question is the land belongs to GA department and my lord, it clearly violates the lease deed. My lord, I request my lords to have page number 19 of the writ petition. My lord, it sets out the lease deed conditions which clearly prohibits that this. My lord, it says that not to keep or store any dangerous or inflammable substance or keep for sale or storage any intoxicating liquors on or in the demised premises or keep any cattle or animal for profit. My lord, when the lease deed clearly prohibits, the 2016 letter of the GA department provides for the closure of the shop. My lord, then at this point, there is a question.
No, but why do you have no grievance? In your rejoinder, you say OP5, in response to that para 3, that you have no grievance against another foreign liquor shop in the name of Preeti Bar, which is situated within 100 meters. Why is that?
My lord, honestly, my client is not aware of the running of Preeti Bar. They know there is something existing, but...
No. What you've said is something else. Come to para 3 of your rejoinder.
My lord, it states that the petitioner has no grievance against another foreign liquor shop. My lord, it's because the petitioner herein is the Hockey Gangpur presided by the Honorable President of Hockey India right now, Federation of Indian Hockey Association, Mr. Dilip Tirki. This Hockey India office belongs to the settler of this trust is Mr. Dilip Tirki. It is situated over SCR 58. And my lord, this bar is operating on SCR plot number 59. My lord, ruckus is being created every day. I have personally witnessed that.
This Preeti Bar is where?
No, my lord. Preeti Bar is not there in that road.
Within 100 meters.
Para 3, sir.
My lord, it's not in that lane, my lord. It is just situated. It's a main straight road right next to the exhibition ground road. There is no alternative road therein. In one straight road, first comes the Preeti Maharani Bar and next comes the Hockey India office, my lord, situated over SCR 58. And directly affected by the activities. And my lord, this situation, this grievance is not coming upfront right now before the honorable bench. My lords, we had given the
para 3, sir.
My lords, that the petitioner has no grievance against another foreign liquor shop in the name and style of Preeti Bar, which is situated within 100 meters distance from the present bar. My lord, honestly speaking, we are not affected, even if it is happening there in Preeti Bar, some nuisance is being created. We are not aware because it is not located in our vicinity, my lord. It is 100 meters. I am not aware. I have never got this from my client.
You are the one who
not located in the next.
You have written it. You're saying you have not heard it.
My lord, it's not in that road. It is somewhere. It is written 100 meters. I was not there when this rejoinder was filed, my lord. But honestly, I have visited the office multiple times.
He is engaged after filing of this rejoinder, I think. But it is adjoining. Both the bars are within 50 to 100 meters.
My lord, but in the straight road, it's just one bar right annexed to the building of Hockey India's office. Hockey Gangpur's office. My lord, all the Indian players come there. My lord, they see ruckus happening. Not just that, it's a residential area.
What was the last FIR when it was filed about the ruckus?
My lord, I don't have the details of the FIRs with me.
You have to show us something, because otherwise for 8 years...
Sir, everywhere...
My lord, but I challenged the violation of lease deed conditions.
You say the present petition filed as a public interest litigation questions the grant of an on-shop license.
My lord, at least a reply from GA department would do.
Respondent, opposite party number 7. Sorry, opposite party number 6. Stated to be the owner of single quotes Maharani Bar and Restaurant, unquote. In Kharvel Nagar, Unit 3, Bhubaneswar District, Khurda. There has been no interim order passed by this court in all these years. In all these 8 years during which the petition has been pending. Paragraph. The on shop in question has been functioning for during this entire period. Full stop. When asked whether cause of action still survives, counsel petitioner states that since the Hockey India office is situated very close to
Hockey Gangpur, Odisha.
Hockey Gangpur, Orissa. Office of the Hockey Gangpur, Orissa is situated close to this shop. Nuisance is created. Full stop. However, he is unable to give details of any FIR that may have been filed as a result thereof. Paragraph. Considering that the shop in question has been functioning for over 8 years, and the petitioner is not able to point out specific instances of inconvenience, the court permits the petitioner to file a fresh petition if any cause of action arises in future.
Would I just like to bring some development to my lord's notice? Registration of this organization has been cancelled. He had challenged, yes, he had challenged the matter this honorable court and had dismissed as withdrawn. Kindly see.
Oh. It's further added that the registration of Gangpur, Orissa.
For convenience.
No.
Hockey
This
Gangpur.
case is not related.
Yes, ma'am. Yes.
Hockey Gangpur.
Yes.
My lord, I had appeared in this
Hockey
case.
Gangpur, Orissa has been cancelled. And the challenge to the said cancellation in writ petition civil.
My lord, the Hockey India is dissolved.
2020 bracket Hockey Gangpur, Odisha versus Hockey India and others. Bracket.
My lord, this is a different
withdrawn
case.
when order dated 23/2022. All right.
My lord, this is a different case, and Hockey India is dissolved since the withdrawal of Narendra's
court is not inclined to pass any further orders in the present petition. It is dismissed as such. All right.
Great. My lord.
Item number 78.
78. Lordship, kindly see the order dated 24th January. My lord, your lordship directed to file a complaint affidavit in
Yes, I have filed
yesterday. Yesterday. Copy may be served. Yes, I will.
Copy of the counter affidavit stated to have been filed yesterday be served.
Complaint affidavit. Complaint affidavit.
Compliance affidavit.
This is Moitris
stated to have been filed yesterday be served on counsel for the petitioner.
Oh, that is why a good Mr. Mohanty, who was appearing, is not available. He is because his catered operation is there. Okay, that is. I will serve copy on Mr. Das. Serve a copy, and I will find it out. My lord, take instruction from the petitioner or whatever. This is regarding, my lord, CCTV camera arrangement and safety measures so far as Medical College and Hospital is concerned, my lord. Your lordship give 3 directions and require status report from the technical team and the fire safety certificate. And so far as CCTV camera is concerned, those CCTV camera is not working. The position that they have to, my lord, intimate like this, my lord. So let them serve a copy of the compliance affidavit so that, my lord, I can give a reply.
What date is this compliance affidavit?
My lord, it is as per my record. It's on 16th Jan. No.
No, can't be.
No.
Because
20th March 2023. 20th March. 20th March.
that's
Monday.
not come on record. A copy of the said affidavit be brought on record as well.
My lord, I am filing the hard copy right now.
All right. List on.
Copy. My lord, your lordship may record that copy is served to the other side.
Right.
And I.
List on 14th August.
Lordship has fixed 14th.
Item 79.
Lordship has fixed 14th April, my lord.
14th August, sir.
14th August.
Item 79.
Small issue involved in this petition, my lord. There is a big pond in Gopalpur, my lord, consisting of an area of 2 acre 38 decimals. And the
you were to file an additional affidavit. What happened?
Now, what happened? There is a recommendation by the collector to the municipality for construction of the road, and the 2 persons are donating their land because there is in between the pond and the government land. There is intervening a private property. So therefore, those 2 persons are donating the land. And it has been objected on the ground that since the property has been recorded under the Kisam Jalasaya, so therefore that land cannot be taken on donation. In the meantime, the 2 consolidation revision, my lord, that has been changed to Sarada. It is not the Kisam of Jalasaya. And that because the property was originally in the Sabik settlement, it was the.
So you were to file an additional affidavit.
Yes, my lord. I will file an additional affidavit by incorporating those orders, my lord. because we are obtaining.
If you want time, you say, I want time.
Yes.
Your Lordship,
You want more time to file an additional affidavit.
Yes, my lord.
You say that. Counsel for the petitioner seeks more time to file an additional affidavit in terms of the previous order. The additional affidavit now be filed at least 1 week prior to the next date.
My lords, my intervention application is pending, my lords.
List on 10th August. Correct.
Item number 80.
May I please, Your Lordship? May pardon to appearing through VC, my lord.
Yes.
Your Lordship, may kindly period the order date 19/9/22 and 30/11/2022, my lord.
You want to take instructions.
This is a matter involving encroachment of public road and selling of intoxicated articles in front of the school, my lord. Though the encroachment case has been initiated in 2021, it is still continuing, and surprisingly, electricity connection has been given by the authority to that premises. I have filed an additional affidavit.
My lord, despite 2 adjournments granted on 19th September
My lord, may I
and 30th November 2022, the opposite parties are yet to file affidavit regarding the current status of the encroachment cases. If no affidavit is filed on or before 8 May 2023, then cost of rupees 25,000 will be paid to the Orissa High Court Advocates Welfare Association. And proof of payment of such costs will be placed on record for this court. So, additionally, Tahsildar Tirtol will remain present in virtual mode for the court on the next date. We'll stop if the affidavit is filed as directed. The petitioner may, if it so chooses, file a rejoinder thereto before the next date. List on 17th May.
My lord, in this case, I am appearing for OP number 3. A copy of affidavit may be served.
All right.
Item 81.
My lord, it was said that if the affidavit is yes, oblige.
Item number 81.
I'm applicant in person. Lordship, this PIL is based on 2 orders. One is issued by Government of India Union Cabinet, another is Parliament. Lordship, the Government of India order is annexed at 11, page number 71. Lordship, may client appreciate the order. Page number 71, annexer 11. The order is at operative part of the order is at para 7, 74, page number 74. May I read, please? The department specific recommendation which are not included in this resolution shall be processed by concerned department, ministry, and approvals of government obtained in consultation with Ministry of Finance and Department of Personnel Training. Lordship, this is the resolution of 6th CPC. And the next operative part is page number 76, para 16. The decision taken on other recommendation of general nature made by the commission which are not included in this annexer will be notified separately. Lordship, there is a clear instruction which are not included in this resolution that should not be paid to any employee.
Yes, ma'am.
Yes, sir.
We have filed the counter, my lord.
No, last time you said I want to take instruction of the rejoinder filed by him. Last order.
Yes.
Where is the rejoinder?
In that part, we have not received any instruction, ma'am. As regard to the fabrication of rejoinder, they have taken a paragraph 10. He has taken a stand that hence the notification dated 1/9/2022 is a fabricated document created and prepared by the respondent to the defendant in the case. In that respect, we have sought for instruction, my lord, I ask it.
You are saying the government has fabricated a document.
Lordship, the Gazette notification itself not a government decision. Gazette notification is a form which is prepared by a official.
And it is, I have filed in this regard, the procedure how a gazette notification prepared. That gazette notification never been approved by the government. Let's say it has already proved. Let's say, may I please consider page number.
Anyway, you produce the records, that will be enough. All right. Relevant records we produced. On the next
21 of
the relevant records regarding the notification dated 1st September 2022 issued by the Government of India, which is annexed as what? This will be annexed to your counter.
No, my lord. Yes, there is a copy of the page 12 to 17. This is our preliminary counter 1/9/2022. There is annexer 1, page 2, running page. Sorry, my lord. I have not paginated, that's why. This gazette notification. Annexer I.
Annexer R.
Yes. Page 12.
I. Bracket annexure I. We produced this gazette notification, according to, is fabricated.
Annexer 2 also fabricate is a absolute document, which is they have saying that.
See, you're saying Government of India fabricates documents.
Lordship.
This is the problem when you are a party in person, sir. You can say anything.
Lordship,
you have the freedom of speech.
Lordship, during the pendency of the case, they are defending to that the individual is a gazetted officer. They have published this gazette notification. Otherwise, if he is a gazetted officer, he should be published in initial recruitment rule. Lordship, the initial recruitment rule is placed in this way. Lordship, please see page number. Page number 87. Page number 87, the gazette notifications are published by them.
PIL is for my lord, and he is working in the department. He is still an employee of the Government of India.
I don't know how he is able to say these things.
Lordship, page number 90. Please see page number 90. The senior account officer is a non-gazetted officer. Now he is a gazetted officer. How and he becomes a gazetted officer?
All right. You see, the present petition filed as a PIL is by a person who appears to be Havildar, who describes himself as Havildar / clerk bracket SD AEC, with a whole host of prayers, including washing the Central Civil Services bracket revised pay rules 2008 and civilians in defense services bracket revised pay rules 2008. On the allegation that unauthorized gazetted status and pay is being accorded the post of Assistant Accounts Officer in the office of the Controller General of Defense Accounts. In response to the notice issued in the petition, the preliminary counter affidavit has been filed by the opposite parties. That is the Deputy Controller General of Defense Accounts in the Ministry of Defense, stating that a hypothetical grievance has been raised by the petitioner without proper knowledge of the functioning of the government machinery. Full stop. As regards tabling of the recruitment rules notified under Article 309, reference is made to para 5.3 of the instructions issued by the DOPT by an office memorandum dated 31st December 2010, which reads as under, take from bottom of page 151, top of page 152, paragraph. As regards the post of Senior Accounts Officer in the Defense Accounts Department, copy of the relevant recruitment rules as notified in the Gazette dated 10 September 2022 has been enclosed as Annexure I to the short counter affidavit. The said rules are called the Defense Accounts Department bracket Senior Accounts Officer bracket Recruitment Rules 2022. Full stop. It is pointed out that in view of the clarification issued earlier, these RRs are to be treated in force from the date the rules are notified without having to be tabled in the two houses of Parliament. Full stop. As regards implementation of revised pay scales, it is stated in para 18 of the preliminary counter affidavit as under, reproduce the whole of para 18 paragraph. In the rejoinder filed, the petitioner has alleged that the above Gazette notification dated 1st September 2022 is open quotation false and fabricated document made to defense bracket SIC the case. Full stop unquote. The petitioner who appears in person repeats the above allegation in court without being able to substantiate such a wild allegation. Full stop. Considering that what has been enclosed with the preliminary counter affidavit of the Deputy Controller General of Defense Accounts in the Ministry of Defense is in fact a photocopy of the said Gazette notification. The court rejects the above outlandish allegation of the petitioner who appears in person. Full stop. The court is constrained to observe that the present petition does not appear to be bona fide at all and has resulted in an utter waste of court time. Stop. The petition is accordingly dismissed. Yes.
Item number 82.
Lordship, may I permit to appeal against the
Yes.
Item 82.
appeal against the
Who's in 82?
Lordship, they are not followed the actually rules. They are not proceeding to Parliament.
We have heard you, sir. We have heard you. All right.
My lord, along with me, Mr. Kashyap is appearing.
All right.
82.
82, I pray for 3 weeks time to file a rejoinder. I received the counter just before the 15 days.
All right. Rejoinder to be filed for the next date, 10th August.
Obliged.
Item 83.
My lord, it is the matter pertaining to the vacancy of members in State Commission for Protection of Child Rights.
That we have complied partly. 3 members have already joined. I am giving the notification.
8.
And Anita Behra, Sasmita Nanda, and Chabi Mahali.
Copy of a notification dated 14 March 2023. Issued by.
My lord, one submission I have to make.
1 minute, sir. Let me just record it.
Right.
Issued by the Department of Women and Child Development, Government of Orissa, appointing 3 members of the Odisha State Commission for Protection of Child Rights, bracket OSC PCR, bracket, has been produced before the court. So there are still how many vacancies left?
There are 6 members.
6 members.
Considering
Only
that it's
3
a
members have been
3 plus 1, 4.
Yeah, that the OSC PCR has 6 members apart from chairperson, is it?
Apart from chairperson, my lord.
So
There
now
are still
the quorum is over.
Yeah, there are still 3 posts vacant.
But my lord, there is a rule that if any vacancy arises, it will be filled up within 180 days. I want to place it.
All right.
We'll fill up it within.
All right.
Because the vacancies are running from 2020, my lord.
Right.
Out.
Mr. Das, appearing in person, draws attention to the OSC PCR rules 2009, in terms of which
Section 17 of the Act, my lord. In Rule 6, Sub-Rule 6.
Rule 6 bracket 6, which states that a vacancy
caused by death,
resignation, or any other reason shall be filled up by nomination, open quotation, within 180 days, date of occurrence of such vacancy, unquote. He states that the vacancies, the 3 remaining vacancies have already been caused in the year 2020 itself. Paragraph Mr. Manti Learned AGA states that the department will take steps to have the remaining 3 vacancies also filled up shortly. So list on. 4th July.
Obliged. Item 84.
Right. Here what has happened under Annexure 1, your lords will find the land was settled in my favor, and I've given the English translation. At page 14, your lords will get the last page, last paragraph. Perused the report of CG2 and found the petitioner is in possession of LR plot number so and so. The petitioner is in possession and had purchased from the rightful owner. Separate recording may be made in her favor as per the trace map attached. So after this, the proceeding was completed. Then I approached them for grant of patta, separate patta in my name. Under Annexure 2, at page 18, I have said that second paragraph, in spite of the order, yet your office has not issued me the parcha land register, though the same has been granted to other tenants of the Tirtol Mauja. Then, my lord, they have asked me to fill up a form for application of the parcha. I filled up the form and they treat it as an objection case under section 9. Once the proceeding is
Single judge has
complete.
passed a one paragraph order.
Yes, ma'am. And thereafter, they proceeded as if some objection case is proceeding. I came before this honorable court saying that since my grievance is, there is no grievance against the government, parcha was to be granted only to issue the copy of the parcha, nothing else. My case was adjudicated properly. Then Honorable Single Judge says that you raised that objections about the ownership under section 11 of the.
What's the position here?
My lord, his objection was treated as an objection under section 9. So once it is
No, there's no objection. He just wanted a.
No, that prayer is to be treated as an objection case in consultation operation. Everything is registered as an objection case.
No,
Not that it is a prayer. And the Honorable Single Judge has said that you raised this point during the stage of 11, section 11.
And as on today, the consolidated proceeding is over.
It's
already over, he says. Consolidation proceeding.
In 2015 itself, it is
Then
over.
he should have.
No, your lordships wanted them to take instructions when I made that submission. As early as in 27/6/2014, records were called for and instructions were sought for. Entire
2014.
Let it go back, sir. The challenge in the present writ appeal is to an order dated 17 February 2014, passed by the Learned Single Judge, disposing of the appellant's writ petition civil 23915 of 2013, in which the appellant had sought a direction to the Assistant Consolidation Officer of Tentulipada, PS Tirtol, District Jagatsinghpur, for issuance of an extract copy of land register / parcha of the landed properties over an area of AC 4.18 decimal. No, over certain plots of land. Over certain plots of land. Thereby questioning proceedings initiated under the consolidation proceedings initiated under the OEA Act, is it? No, under the OCH and PFL Act, 1972. Good stop. The impugned order is a non-speaking one, which reads as under, reproduce the order at page 27. Counsel, the appellant points out that the consolidation proceedings concluded in 2015 itself, and there was no occasion to file any objections in the consolidation proceedings as such concerning ownership of the land, as that was never in doubt. Full stop. In any event, the court finds that the impugned order has been passed, perhaps on the very first date, without any opportunity to the state to file a reply to the writ petition on merits, and to decide the writ petition after considering such reply. In that view of the matter, the impugned order is hereby set aside and writ petition civil 23915/2013 is restored to the file of the Learned Single Judge in the roster bench, where it will be listed on July 10th, 2023. The reply to the said writ petition be filed by the opposite party state on or before 26 June 2023 and rejoined that too before 10 July. The Learned Single Judge, you say the consolidated cost title of the writ petition, reflecting the changes as recorded in the cause title of the writ appeal be filed by the counsel for the appellant before the learned single judge by 26 June 2023. First, the learned single judge will proceed in the matter after issuing notice to the remaining opposite parties who may not have been served, and endeavor to dispose of the writ petition thereafter as expeditiously as possible. The court clarifies it has not expressed any view on the merits of the matter. The writ appeal is disposed of in the above case.
Item number 85.
85, I pray for a short adjournment. Because the Mr. Bijan Rai was appearing in this case. And he, in the meanwhile, he is expired. I have to inform the OSFC to whom they will engage.
Mr. Rao was appearing, my lord. This unfortunate petitioner, my lord, he filed case, a retrenched employee, my lord. He filed case in 2000, and my lord, it was disposed of 14 years thereafter in 2014. Judgment in his favor to be re-engaged and with full consequential benefit, my lord. But that was not given him, my lord. And he filed writ appeal, no stay order was granted. And in the content proceeding, first content, my lord, order was passed to comply the order within a short date, my lord. But that was also not complied with, my lord. My lord, the order dated 14/10/15, my lord, I may permit to read that it is stated that the judgment dated 7/8/14 passed by the court in OJC number 8 has not been complied with. Let the authority comply the same, if not complied with, within a period of 2 months from the date of communication of this order. This order was passed in 2014, my lord. And when, my lord, they filed writ appeal, my lord, in the writ appeal, the order was passed that they may comply the order, my lord, within a reasonable time, my lord. My lord, intentionally they have violated the order, my lord, and the petitioner is now, my lord, aged about 57 years, my lord. And it has taken, my lord, 14 years for disposal of the writ petition, and thereafter another 10 years has been lost, my lord. My lord, this is the attitude of the OSFC corporation, my lord, and the council engaged, my lord, Mr. C. Rao, senior advocate, was engaged in this case, my lord. He has also filed the writ appeal, my lord. And now, my lord, a submission is made that the senior counsel who was engaged, he is dead. My lord, it is the responsibility of the OSFC, my lord, to engage any other counsel on that ground. They cannot, my lord, delay in the matter, my lord.
Only I pray, my lord, a short adjournment may be given so that I will inform the OSFC so that he may engage on any other counsel.
Another content, my lord, I have filed, my lord. That is 1823/16, my lord. That has come, my lord. And my lord, in that case, my lord, now they have violated 3 orders, my lord. One is in the writ order, another is in the first contempt, and another is that miscase they have filed, my lord, in miscase number 49/16 in that writ appeal, my lord. This application has been filed by the opposite parties for extension of 2 months' time to get the interim order in the writ appeal or to comply with the judgment dated 7/8/14 passed in OGC number so and so, my lord. Considering the contention raised by the petitioner, 1 month time is allowed to the opposite parties either to get an interim order or in the writ appeal or to comply the judgment dated 8, my lord. My lord, this was passed as back as in 2016, my lord. No stay order was obtained, and my lord, they are sitting silent, my lord. Your lordship may, in the content, my lord, your lordship may pass appropriate order, my lord, because they have deliberately, my lord, they have violated the order, my lord. Repeated orders of this honorable court, my lord. And the poor petitioner, a 4th grade employee, is, my lord, without job, my lord, and also he has not get his back wages, my lord, also for the days he had worked, my lord. And during this, my lord, pendency of this writ appeal, my lord, the council was making a submission that we will give him employment, but we will not give the back wages, my lord. This is the attitude, my lord, of the corporation, my lord. The officers who were there, my lord, they were very adamant and they were sitting silent not to implement this order, my lord, for the reasons best known to them, my lord.
No, there was an undertaking not to proceed with the contempt petition on 5th February, and statement was made that you will not proceed with the contempt petition. And then on 9th February, they allowed the, I think petitioners, it says, must be appellants, to file an application before the appropriate court for modification, extension of time granted for compliance with the order passed in contempt petition. Did you file that application in the contempt petition? This case. Yeah, for extension of time. You're the advocate whose wakalatnama is on record.
Yes, Mr. Rao was earlier engaged. Subsequently, Mr. Vijan Rai was appearing.
No, no, what, who,
Mr.
do you have your wakalatnama?
Earlier, now, yes, my lord.
The council
So
was
don't answer.
Mr. C. Rao is yes, my lord.
So just answer a simple question. Is your wakalatnama on record?
Yes, ma'am.
What is your name, sir?
My name is S.K. Behra.
S.K. Behra. All right. Why can't you argue the matter?
Because Mr. Vijan Rai is appearing and the brief has been handed over to Mr. Rai.
No. Brief has handed over, meaning you are no longer appearing.
No, earlier Mr. Rao is appearing.
Today, just answer this question. I'm not talking about earlier. Today, are you appearing or you are not appearing?
No, this is my instruction, my lord, because I have to inform the OSFC. Otherwise, I would not have requested this honorable court marriage to take time. Is short urgent tomorrow or day after tomorrow?
No. Are you the lawyer on record for OSFC?
I cannot work. Mr. Rao is appearing. Mr. Sierra Senior.
You don't understand the question, sir? Just show the paper.
He is the panel lawyer of the OSFC.
Huh? Your name is there.
Mr. Sierra, senior
S.K.
advocate.
Behra, your name is there.
Yes, my lord. Yes, along with Mr. Sierra.
So you are there. You are the advocate whose wakalatnama is on record.
And the senior counsel, Mr. Sierra, is appearing also.
We're not on the senior counsel, sir. You're the advocate who's filed a wakalatnama.
My lord, because the panel lawyer of the Mr. Sierra, my lord. The senior advocate, my lord.
Mr. Sierra was there, not today. He was appearing in some matter today.
Yes. No.
He was appearing today.
SS Rao, my lord.
Sierra.
My lord, may I pray kindly taken up tomorrow, my lord, at least.
All right, you say the request of counsel of the appellate list tomorrow.
Item number 86.
May please. Your mind of the Odisha Khadi and Industry Board is the appellant before your lordship challenging the order passed by the Honorable Single Judge. Here, my lord, during the year, here, my lord, the Odisha Khadi and Industry Board has no source of income after being assistance by the Odisha Khadi Commission of India. It used to floated the schemes. And as has been done in this case during the year 95, my lord, there was the scheme was floated.
The stay was rejected already.
My lord.
There was a specific order rejecting your application for stay.
My lord.
So have you implemented the impugned order or not?
No, my lord, we have not implemented.
Then that's a simple ground for rejecting your appeal, sir.
Now the problem is, my lord, the money which has been with the Odisha Khadi that has been refunded to the commission, and now the scheme is also not available. So it will be, since the money is not there, that cannot be. That to my lord, dear lordship will find during the 95, my lord, there was a scheme, and because you could not fulfill the condition, the subsequent amount has not been sanctioned. That is the stand taken by the Odisha Khadi and Industry Board. Now, my lord, in the meantime, the scheme is not available also. That too, the government of India has already abolished that scheme. Here, my lord, because there is no recovery platform of the Odisha Khadi and Industry Board, it used to place the money, being assistance by after taking finance from the Commission of Khadi Commission from India, it placed with money with the bank. And bank is to pay and recover the amount. And here what happened, my lord, the 2 lakh out of 10 lakhs, 2,50,000 has been sanctioned, but that only could not utilize this sum.
Anyway, you say the challenge in the present writ appeal is to an order dated 17 November 2014, passed by the learned single judge, disposing of writ petition OJC number 2393 of 2001, filed by the respondent. By the impugned order, the appellant, that is the Kadi Village Industries Board (KVIB), has been directed to release the balance sum sanctioned to the respondent by the KVIB. For setting up of a brick unit. Paragraph. It has been inter alia noted in the impugned order that although inspection was made and a recommendation was made and a recommendation submitted, for release of the balance amount, the KVIB declined to do so on the ground that it was not satisfied with the inspection reports of the respondent number 2, Khurda Central Cooperative Bank Limited. Paragraph. As noted by the learned single judge, no reasons have been adduced by the KVIB for not accepting the inspection reports of the bank. Or that the utilization certificate given by the bank was not single quote satisfactory. As noted by the learned single judge, the appellant KVIB also did not bring on record any document to show that respondent number 1 had been made aware of the defects in the utilization certificate. Full stop. Paragraph. Having heard learned counsel for the parties, the court is not satisfied that any ground has been made out for interference with the impugned order of the learned single judge. The appeal is accordingly dismissed.
My lord, kindly indicate that now in the meantime the scheme was allowed and abolished by the government of India. So that my lord, kindly indicate that this is my abhorrence in my member.
All right. Although the KVIB indicates that the scheme under which the loan was sanctioned, financial assistance was sanctioned to the respondent 1, has since been closed. It still does not absolve KVIB of the obligation to comply with the directions issued with the impugned orders. Stop. It may be noted here that by an order dated 10th April 2019, this court had specifically rejected the prayer for, by an order dated 19th April 2019, this court had specifically rejected the prayer for stay of the impugned order. And that order was not challenged. Full stop. For the aforementioned reasons, there is no merit in the writ appeal and is dismissed as such. This contempt case 1071 of 2015 placed before the roster bench of the learned single judge for directions on 3rd July.
Well, I would say respondent number 3, not 1. 3 has closed. That Khadi Village Industry Commission. She was a respondent 1, but that is respondent number 3.
All right, I'll make it up.
Instead of respondent 1.
All right.
Item number 87.
May I please, Your Lordship? Well, here the appellant has challenged the order of the learned single judge dated 28/2015, my lord, under Annex 7. Lordship, kindly have a glance at the input order under Annex 7, my lord. Lordship is a 2-page order, my lord. Lordship have kindly have a glance at page 64, my lord. Mr. K.K. learned counsel for the petitioner states that the learned tribunal has passed an erroneous order and therefore he has approved this court by filing the present writ petition for quashing the same. Mr. Rajit Roy, learned counsel for OP number 5, has filed an additional affidavit indicating that the petitioner is no more in service in the institution in question, and though the opposite party number 4 has succeeded in the appeal before the learned tribunal, she has not been allowed to join against the post for last 4 years. He further submits that the petitioner, without resigning from the post of trained graduate teacher in Birsa Munda Adarsh Girls High School, undertook a contractual engagement in Ispat English Medium School, and she joined as a temporary teacher with effect from 1 September 2012. And the post of trained graduate teacher in Birsa Munda Adarsh Girls High School is still lying vacant. Considering the submission made by the learned counsel for the parties and on perusing the materials available on record, it appears that this court by order dated 14/3/2012 in miscase number 2702 of 2012 passed an interim order that the status quo as on date shall be maintained, and though the interim order has been extending from time to time, nobody is allowed to hold the post of trained graduate teacher in Birsa Munda Adarsh Girls High School, and the said post is still lying vacant. That apart, though OP number 5 has succeeded in the appeal, pursuant to such interim order of this court, she has not been allowed to get the fruit of the order passed by the learned tribunal. In that view of the matter, the interim order dated 14/3/2012, passed in miscase number 2702 of 2012, stands vacated, and the opposite parties are directed to work out the order passed by the Learned State Education Tribunal, Odisha, Bhubaneswar, in accordance with law. My lord, here, my lord, I have raised 3 questions before I have challenged the order of the Learned Tribunal, Education Tribunal, by filing a writ petition, my lord. My ground of challenge was that, my lord, the appeal.
Who are you?
My lord, I am the affected party, my lord. I am the affected party.
What does that mean? What is the meaning of that?
My lord, the respondent, my number 5, my lord, she was appointed in a aided school. After, my lord, she was terminated, I was appointed against her vacancy, my lord.
So this is how you should start arguing the appeal.
Yes,
okay?
my lord.
You should first set out the facts.
Yes, my lord.
Which is this? So she's appointed as what teacher?
Trained graduate teacher, my lord.
Sorry?
Trained graduate teacher.
Trained graduate teacher.
Yes, my lord. Trained graduate teacher arts. Yes, my lord. Thereafter, my lord.
Which is the date? Was she appointed on some date or not?
Yes, my lord.
Which date?
She was appointed 1995.
No date, no month, nothing.
That, my lord, respondent number 5 was appointed 1995. I was appointed in 2005, my lord. That is in 11/7/2005.
Only your date you remember. The other party's date you don't remember.
That, my lord, we have not covered, my lord.
Court judges will assume some date we should put.
My lord, I am extremely sorry, my lord, that we have not covered yet. So
how do we manufacture that?
My lord, the fact of the case is like this, my lord.
What is that fact? Which is the date we'll give? Which date should we give in 95?
My lord, that is there in the, my lord, counter affidavit filed by the inspector of school in the State Education Tribunal, my lord, page 35.
You prepared a list of dates?
Yes, my lord.
Show us the list of dates.
My lord, I will prepare. I haven't prepared, my lord. Sorry, my lord. I was misunderstood.
I was tempted to ask Justice Satpathy to repeat the question because I've forgotten my English actually.
I am extremely
After
sorry.
coming here, completely forgot. Whatever I say in English, lawyers don't never understand.
I am extremely sorry, my lord. Perhaps I was misunderstood, my lord.
I think I am being misunderstood every day. So when will you prepare your list of dates?
My lord, I'll take 1 week time, my lord.
Okay. Counsel Appellant needs time to prepare a proper list of dates and a note of submissions. That is request list on. 17 docs.
Item number 88.
Oblige, my lord.
Item number 88.
None appears dismissed.
Item number 89.
Wait, please, George. On the last occasion, Mr. Mishra had taken time to obtain instructions on my statement. That
one thing I'm sure Mr. Vaidyanathan and Mr. Mishra is very envious of where you're sitting. Here it's raining.
That's the background.
And you're in sylvan surroundings.
The greenery at the background, my lord.
All right. Yes.
Last order, if your lordship looks at.
Yes.
But we discussed with our client, my lord.
Right.
They were very happy that the your lordship makes a suggestion for settlement of the amount in the parties.
Correct.
But they actually wanted to bring your lordship's notice a few things, my lord.
Right.
Number one is, if the award remains, my lord, till date, it may be 21 crores.
No, this will be in substitution. Whatever order will be passed in substitution of the award.
Right. 21 crores, my lord.
Yes.
He suggests that if your lordship kindly fix with my friends, clients can also be discussed, that it can be 7 crores or in between that. 1/3 of the amount actually, which actually it comes to the, as per the order.
There's the principal
many years
amount
have
is
passed.
1 crore. There is no dispute.
Yes.
Because of the claim that it is an MSME, the huge interest has been calculated.
Right.
There is no dispute about the principal amount of 1 crore. We are disputing the very character as an MSME. Therefore, we had offered 9% interest. Your lordship may perhaps consider making it.
You also mediate, my lord. We also agree. You also mediate, find out the solution to that, my lord.
It can't be. What they are asking for is a rate of interest of 60%.
No. I think right now he's offering that you go for mediation. He's saying approximately they're looking at 1/3 of the total amount being the amount.
Principal amount, there is no dispute. Even as per the award, it is 1 crore.
Correct. So the negotiation obviously will be on the interest.
That's right. That's right.
So if you're prepared to take one shot at mediation, why don't you do that?
I have no problem in taking it.
All right. Mr. S.P. Mishra and his senior counsel, appearing for respondent 2 on instructions, states that respondent 2 is willing to go in for mediation on the issue of the interest payable on the sum of ₹1 crore, as offered by Mr. Vaidyanathan, learned senior counsel appearing for the appellant on instructions, and as was recorded in the previous order dated 21st February 2023. Full stop. Mr. Vaidyanathan expresses his consent to go in for mediation. Full stop. The representative of both the representatives of both the appellant as well as respondent 2, where are they located? So I don't know where they.
Karnataka. My client is in Karnataka, but whichever place.
They can even do an online mediation.
Yes.
We'll sit with their respective counsel, and the representative of respondent 2 will sit with their respective counsel and go in for an online mediation on any mutually convenient date in the next 1 month. Date or dates in the next 1 month. Stop. The court be informed of the outcome on the next date. We'll have it in the opening.
There is an interim order passed on 5th of May 2000.
That will continue, sir. That will continue.
Yes, that may continue.
List on
3rd July, interim order to continue.
But you should indicate one thing. Online mediation, he's also representing his friend is there.
Online or physical, if the physical if the companies do send a physical person.
Come here and it is also.
Yes.
Physical or online, whichever way.
Yeah.
Option is open.
Yeah, in hybrid mode. You say go in for mediation, hybrid mode.
Right.
Great.
All right.
Great.
Item number 90.
May I please, Your Lordship?
Yes.
Your Lordship, order dated 26/7/2022 directed the secretary to file an affidavit. How many similar situated employees have been regularized? And subsequently, Your Lordship, order dated 2010/2022. Till yet, the government has not filed affidavit.
Well, I have received instruction from that CDP officer that is not sufficient. I have to file a reply from the government, my lord.
All right. Last option is already granted, sir.
Your lordship, last opportunity. 7
You
days.
say, despite adjournments granted on 26 July 2022 and 20th October 2022, the opposite party state is yet to file an affidavit, counter affidavit, as directed. File the affidavit as directed by this court, giving the details of how many open such like persons have been appointed on regular basis by way of regularization. Unquote. One more opportunity is sought today. Stop. It is made clear that if the affidavit as directed is not filed, on or before 3rd July 2023, cost of rupees 25,000 will be paid to the Orissa High Court Advocates Welfare Association, and proof of payment of costs will be placed on record. Further, if the affidavit is not filed as directed, the Secretary, Women and Child Development Department, Government of Orissa, shall remain present in virtual mode on the next day. List on July 12th July, sir.
Supplementary list, pastor matter, item number 33.
There is after 10 days, can be condoned. This is shilling proceeding. My so much shilling case was initiated against the one Radhanatha Bhavarta Patnaik. During the pendency of the shilling case, he died. No substitution was made, nor any press shilling case was initiated against him. There is no scope for filing appeal or a revision by the legal heirs. Therefore, they moved the Land Reform Commission Resolution 1592 to refer the matter to Board of Revenue for hearing the case on merit. The Commissioner of Land Records, who passed the order, he has said, since his son is appearing and informing the court that his father is dead, therefore there is no substitution. My humble submission is that since the one shilling holder when died, a shilling proceeding cannot be proceeded. It is a nullity. But thereafter, the commissioner said that no appeal or revision has been filed. Who will file? When the legal heirs have nobody, no appears there. And Honorable Single Judge, I have placed an annexure 1 line for a long note of argument, but Honorable Single Judge has passed the order saying that no appeal or revision filed. So that is not a complete case. Can I see annexure 2, the order? But there are two questions raised in the case. The shilling holder is died, therefore the shilling proceeding is nullity one. And secondly, 4 villages out of 8 villages have been declared urban villages. So under section 73 of the Olar Act, that is Olar proceeding is not applicable to urban areas. But the legal heirs have not participate to the proceeding. The question of appeal or revision does not arise. Can I see the order in annex to by Honorable Single Judge?
What is this annexure 5, which is referring
Annex 5 is the order of the Commissioner for Land Records Settlement.
Land Reform Commissioner's order.
Commissioner order 592.
That you have not challenged?
Yes, I have challenged in the application.
Oh, I see.
And his son was petitioner before the LRC, I think.
Yes, his son was.
That is why the Honorable Single Judge has said that your son was representing there. So it is within the.
But he can challenge this order, certainly. How can his right to challenge this 10-5
The outcome
2007
of
order?
that writ petition will squarely cover this matter. So your Lordship may say that writ petition may be tagged with this writ appeal.
Which one?
That order against LRC. You have filed a writ petition.
No, 19370 must be that writ petition, sir.
Yes, madam.
That is what has been dismissed by the impugned order.
Yes, my lord. 19370. By the annexure 1, I have submitted my written note of submission reiterating everything. By the
It's one bundled up writ petition.
Yes.
He challenged that Aadhaar order.
No, one
direction.
One writ application.
I know, with several prayers.
Prayer only because of during the pendency of the shilling proceeding, if the shilling holder died.
You say the court finds that the impugned order of the learned single judge does not deal with the challenge raised by the petitioner, by the appellant public petitioner to the order dated 10th May 2007 passed by the Land Reforms Commissioner in OLR revision case number 14 of 2006, which was squarely challenged in the writ petition. So stop. The impugned order proceeds on the basis that the said order has attained finality. So if indeed neither an appeal nor revision is maintainable against the said order under the Orissa Land Reforms Act, then the appellant's right to challenge the said order in a writ petition could not have been denied. Full stop. It was the second prayer which was for a direction to the LRC to refer the matter to the member Board of Revenue under section 59(2) of the OLR Act. Full stop. If this would depend on the outcome of the challenge to the order dated 10th May 2007 of the LRC, which was not considered on merits by the learned single judge. That view of the matter, the impugned order is hereby set aside. And writ petition civil 19370 of 2008 is restored to the file of the learned single judge, the roster bench, where it will be listed for directions on 10th July 2023 to be proceeded with on merits in accordance with law. Considering it's a petition of 2008, the learned single judge is requested to dispose it off as expeditiously as possible. The writ appeal is disposed of the above terms. After lunch, we'll come back.
Supplementary list passed over matter item number 63. Item number 63. Writ appeal 1080 of 2022.
Pass it over. Oh, this is already passed over. None appears despite a pass over. Dismiss not.
Item number 71.
None appears despite a pass over. Dismiss not.
Supplementary list fresh admission item number 1, CRLMC 1937 of 2017.
No instruction.
No instructions.
Item number 2.
My lord, item number 2. My lord, here the parties have compromised the matter. There is an appearance also from the opposite party number 2. My lord, the offences under 341, 323, 325, 294, 354, 354B and 34 IPC. Well, they have settled out of court and they have arrived at a settlement, and they have also presented an affidavit which I've got a copy before the learned trial court.
Oh, okay. And what is the trial court done?
Well, the trial before that I had come up. I had come up before that. Before the
but there's no other side here.
Well, our other side, Mr. Patnaik is appearing.
Where is he?
So Patnaik.
No, Amit Patnaik.
I'll place you before the roster bench.
No.
Item number informs the court that one Mr. Patnaik. What Patnaik is he?
Amit Patnaik.
Mr. Amit Patnaik, advocate, appears for opposite party number
2, man.
2. However, his wakalatnama is not on record. He also states that an affidavit has been presented already to the trial court, recording the compromise between the parties. The said affidavit be placed on record. This before the roster bench on 26th April.
That affidavit may be written by your lordship in fact. Item number 13 is also same one.
Same order in 13. Okay.
Item number 3.
Give him back the affidavit. That affidavit be given back to him. 1 minute, Mr. Bose. You'll have to file it, sir.
Sir,
Item 13 the same.
Same.
Item number 3.
None appears.
Item number 4.
Same order.
Item number 5.
Same order.
Item number 6.
Same order.
Item 6, I am appearing for the state vigilance opposite party.
Order. None appears for the petitioner, then put his name for the vigilance.
Item number 7.
May I please, Your Lordship?
Yeah.
Lordship, the impugned order is at Annexure 4 at page 18. Lordship, the learned court below has rejected an application filed by the petitioner under section 205, Lordship. The petitioner number 1 is inspector in charge. Lordship, what I pray, my Lord, I may be liberty may be granted to surrender before the learned court below. And Lordship may direct that if in that case I may be released on bail.
No, not on bail.
I was on bail throughout the investigation
You
period.
apply, sir, that court will decide. Counsel for the petitioner undertakes that the petitioner will appear before the JMFC High Court on 24th April 2023. It will be it will be open to the petitioner to apply for appropriate orders before the trial court thereafter. The interim order is vacated, the petition is disposed.
Item number 8.
Obliged.
None appears.
Item number 9.
Permitted to withdraw.
Permitted. Disposed of.
Item number 10.
None appears.
Item number 11.
Same order.
Item number 12.
Well, item number 12 on behalf of Mr. H.N. Mahapatra. Let it come next week, man. Pass over, man.
Pass.
Possible. Item 13.
13 already, Mr. Bose.
Yeah.
Yes. Item number 14.
None appears.
Item number 15.
None appears.
Item number 16.
May I please, Your Lordship? My Lord, item number 16 raise all the point learned court below, my Lord.
There's all the point.
Permitting the petitioner. All right.
Obliged, Your Lordship.
Item number 17.
My Lord, item number 17, no instruction.
No instructions.
Item number 18.
What's the name, please?
Lordship, all the offenses are compoundable in nature, and the present petitioner is the practicing advocate of Bhubaneswar Bar Association. In the meantime, the compromise has been settled between themselves, Lordship.
Where is that?
Lordship?
Where is that?
And I have not got it, Lordship.
Place it to the roster bench and file an affidavit. Counsel, the petitioner states that the disputes with the informant have been compromised, have been settled. He undertakes to file an affidavit. The disputes with respondent number 2, opposite party number 2 have been settled. He undertakes to file an affidavit to that effect before the next date. Let's before the roster bench on 27th April.
Item number 19.
None appears to.
Item number 20.
May it please, Your Lordship? My Lord, I am VC, my Lord. My Lord, in this case, my Lord, the two separate criminal cases with very same allegation, but which are registered on different offense, my Lord. In both cases, GR case 248/2010 and so also 2BCC case number 41/2013, my Lord. the accused person are same and alleged have been committed in the course of same transaction, my lord. And similarly, section 223 CRPC speaks that person accused of different offense committed in course of the same transaction may be tried at one trial, man.
So there's no interim order.
No, my lord.
By now I think it will be all over, sir.
No, my lord. The case is pending. Both cases are pending, my lord.
How? Without any interim order, how can it be pending?
My lord, the evidence is not closed. Both cases, my lord.
Evidence closed?
No. Trial commenced, so evidence not closed. That
Not
is
closed.
what he is saying.
So it's going on, sir. What inconvenience has been caused then? Trial is going on in both matters.
My lord.
So clearly no inconvenience caused.
I think same court also.
You say
same court.
Then it's okay. During the last 5 years of pendency of the present petition, there has been no interim order. It is stated that the trial in both cases is in progress. Clearly, there is no inconvenience caused on that count. The court therefore declines to interfere at this stage. The petition is dismissed.
Item number 21.
21 pass over one.
All right.
Item number 22.
None appears.
Item number 23.
My lord, no instruction.
No instructions.
Item number 24.
24, my lord, no instruction.
No instruction.
Item number 25.
25, my lord, all the offences are compoundable and I filed an application for compounding. Already, the other respondent said, unfortunately, the sole complainant has been died and these legal heirs are coming forward with this.
Who's LRs? The complainant's LRs.
Yes, my lord.
They have signed this.
The 4 LRs, however, the 2 of the married daughter have not been signed this affidavit.
Then we'll give a date before you say, keep this with you, sir. Get all the affidavits. Counsel for the petitioner states that the matters have been settled with the LRs of the deceased complainant and that he will place the affidavits before the court on the next date. List before the roster bench on 2nd May.
Well, that NBW order may not be given effect to.
No interim order here, sir. So nothing.
Item 26.
So this is my lord, liberty may be given to take these points before the trial court.
Yeah, permitting the petitioner.
Item 27.
In this case, I want to change the nomenclature of the case from CRLM to writ because I have challenged the order annexed 1, that is the decision of the district judge in FAO. But wrongly it was filed as CRLMS.
All right. Counsel, the petitioner wants time to take steps to change the nomenclature of the present petition. Let's move for the roster bench on 9th May.
Item number 28.
None appears dismissed.
Item number 29.
Same order.
Item number 30.
No instruction.
No instructions dismissed.
Item number 31.
My lord, Mr. C.P. Ramaswamy, Advocate Hyderabad, is the conducting counsel for the petitioner. He has gone to Rajasthan, Jaipur. So it is not possible on his part to conduct the case today, even in VC. So I pray the matter may be taken at least 1 or 2 weeks after fixing a date. And the interim order may continue.
You take all these pleas at the appropriate stage, sir. Permitting the petitioner to raise all pleas at the appropriate stage in the trial.
Yes.
The petition is disposed of interim orders.
During the trial, my lord, in the trial, all the points be.
That's what I've said.
Yes.
32 also.
Same order.
32,
32, 33, same order.
In all the cases, I am appearing.
Item number 34.
My lord, I am appearing for the OP number 2. The matter has been settled. I have no objection if the proceeding is passed.
You are for whom?
I am for the OP number 2.
I see. Counsel appearing for OP number 2 states that the proceedings, the disputes have been settled with the parties and he has no objection. The prayer and the petition being allowed. That view of the matter. Take the prayer clause and all proceedings consequent that to hereby quashed. The petition is disposed.
Item number 35.
Yes, item 35. I pray, my lords, that Lordship may grant liberty to raise all the points before.
It's correct. Permitted petition. Great. Or
Item 36.
none applies.
Item number 37.
37, may I please, Your Lordships. Your Lordships, the allegations reveal a case under section 354A and 8 of the POCSO Act. But my lords, charge sheet has been submitted under section 376(2)(f), giving a higher version by hostile witnesses, my lords. The cognizance is at all wrong, Your Lordships.
Permitting the petitioner to raise all points at the appropriate stage. Petition is disposed.
Item number 38.
None appears dismissed.
Item number 39.
May I please, Your Lordship, and item 39, I am praying Your Lordships to give me liberty to raise all the points.
Correct.
Obliged to Lordship.
Item number 40.
May I please, Your Lordship? Lord, this is, my lord, the petitioner challenging the order taking cognizance, my lord. Lord, the opposite partner 2 is a borrower, my lord. He availed a loan from the bank and the cognizance has been taken for the offence under section 28 and 29 of the, my lord, Surface Act. Your Lordship can see order taking cognizance at Annexure 1, my lord. If Your Lordship permit, I have prepared a date set, my lord.
Who are you for, sir?
My lord, the petitioners are the, my lord, branch manager and assistant branch manager of the bank. My lord, when the loan account was declared as NPA under the Surface Act. But in the opposite partner 2, my lord, filed 1cc case before the, my lord.
Who is appearing for opposite party number 2?
Mr. Ravi Narayan Behra was appearing, and throughout he is not, my lord, appearing in the case to argue the matter, my lord.
Mr. Ravi Narayan Behra, who appears for opposite party number 2, is not present today. Registry will inform him to remain present on the next date. List for the roster bench.
Interim order may kindly continue.
There is no interim order, sir.
Yes, my lord.
Interim order to continue. List on. List for the roster bench on 10th May.
Item number 41.
No instruction, my lord.
No instructions.
Item number 42.
None appears.
Item number 43.
None appears.
Item number 44.
May I please, Your Lordship? My lord, the petitioner is challenging the order of cognizance on the ground that compromise. The offences is triable by magistrate and compoundable in nature except 294 and 385. The petitioner was also not named in the FIR. In the meantime, matter has already been compromised. The notice was issued and informant already appeared and also filed
the affidavit of the informant stating that he is not interested in proceeding in the case against the petitioner has been placed on record. In that view of the matter, take from the prayer clause and all proceedings consequent that we hereby quashed.
Okay.
Petition is disposed.
Item 45.
None appears dismissed.
46.
46, my lord, I am Mr. R.K. Malik, permitted to withdraw, my lord.
Dismissed as withdrawn.
Item number 47.
May please, Your Lordship. And there was a dispute, a FIR came into existence, but the parties have sorted out and they filed this application. Your Lordship will kindly peruse order dated 19/8/2019. The Honorable Court was pleased to take note of the developments, and the informant is also for Your Lordship.
All right.
He has also
the informant stands by the affidavit stating that the matter has been amicably settled between the parties. That view of the matter take from the prayer clause and all proceedings consequent that we hereby quashed. The petition is discussed.
Your Lordship quashed it. Deeply grateful.
Item number 48.
May Your Lordship, please. My lord, in this case, the opposite party approached Honorable Supreme Court, my lord, in TP number 542/542, my lord. And there is an amicable settlement and settlement agreement they will reach very soon, my lord. Kindly allow 1 month time, we will submit.
All right. Counsel, very
Supreme Court order in this case. my
Petitioner
lord.
seeks time to produce the order of the Supreme Court and the affidavit of compromise placed before the roster bench on 15th May, interim order to continue.
Grateful, my lord.
Item number 49.
None appears dismissed.
Item number 50.
May I please, your lordship? I am in BC, your lordships. There is challenges regarding polygraph test, your lordships. Your lordships, by order dated 20th November 2018, please to grant stay. There shall be no polygraph test, your lordship. The basically grounds has been taken, my lord. I filed a citation that Selby case, that is 2010.
Correct. You
That
say
the guideline principle has been settled, which has
All
not
right.
been.
All right. You say this court had on 28 November 2018 passed an interim order to the effect that no polygraph test will be conducted on the petitioners. Stop. The judgment of the Supreme Court of India and Selvi versus State of Karnataka.
Yes, your lordship.
Yes.
Paragraph 265, your lordship.
No, give us a citation, sir.
Your lordship. I have already submitted the citation, your lordship. The 2010 volume 7 SEC.
263. All right. 263 is squarely applicable in the present case. The order dated 2nd August 2018 and 24th August 2018 passed by the SDJM Baripada in GR case number 717 of 2017 is hereby set aside. The petition is disposed of. A copy of this order be sent to the concerned trial court. Right.
I'll oblige.
Item number 51.
And I can raise all the points.
Permitting the petitioner to raise all, please. All right.
Item number 52.
I am asking for the informant, lordship. Here is in a case, your lordship, wherein the present petitioner is the headmaster of a school. An alleged incident occurred on 25/4/2018, your lordship, wherein a POXO is there, your lordship. Lordship, what has transpired in the present case is, lordship may see the charge sheet, your lordship. There was a certain incident in which one Chandan Purti had taken away this girl of less than 12 years of age and committed certain acts, because of which the FIR was filed. Initially, the FIR was also filed against the headmaster. But during the course of investigation, it transpired that the headmaster had absolutely no role to play in the alleged incident. Lordship may see the brief facts in the charge sheet, your lordship.
So you raise all the pleas at the time of framing charge.
Lordship, now the informant has filed an affidavit to the effect that I had no role to play.
That can't be taken note of like this.
Lordship, may kindly see, I have been charged with 312, 315, 511 and 201 of IPC, your lordship. Now, when the headmaster is
have to be examined. What is your age? The informant's age?
At the time of the incident was 12 years old.
And now?
The informant is another person, victim is another.
Affidavit is by some, not by the girl. You say permitting the petitioner to raise all pleas at the appropriate station. The petition is disposed of, the interim order is vacated. Right.
Item 53. 53.
None appears.
Item number 54.
My lord, permitted to raise those points at the time of framing of charge, my lord.
All right. Permitting the petition. Raise all please. Right.
At the time of framing of charge.
Whenever, sir.
My lord.
Item number 55.
55, Milos, the complainant is the petitioner in an NI Act case. His case has been dropped. Milos, I have given a list of dates. That I may quickly run through that.
On behalf of Mr. D.R. Sundara, he is appearing for the opposite party. His father is admitted today in the hospital, in the ICU. The matter may be urgent next week or any other.
Counsel for the respondent is in some person. Give it back. Personal difficulty today.
Let them explore explore mediation, because
if
that
but he had to be present, I think. This man.
I will inform you.
My lord.
Okay, I will inform you.
Let him inform. My lord may keep it short.
All right. Parties in the meanwhile will explore the possibility of settlement through mediation. They will appear in the mediation center of the High Court on 17th April at 3:30 p.m. The report of mediation be placed before the roster bench on the next date. List before the roster bench on 11th May.
All right.
But in this case, man, both the forum they have lose the.
Yes. I have in fact got judgments against me, but there is one judgment that which the Supreme Court is examining, that whether 420 under these facts can be applied. So even if it was barred by limitation, the court below could have looked into this from the angle of 420. So the matter can be considered by the court below also in this light. But since he is not there, my lord may.
Item number 56.
None appears dismissed.
Item number 57.
57, my lord, this is a arising out of an 133 proceeding, my lord. The petitioner has a thatched house, and in the neighboring plot there are 8 coconut trees. And under the 133 proceeding, law and magistrate directed to remove the trees. Thereafter, a revision preferred by the opposite party, and in the revision, they interfered with the order of the magistrate and stated that that has been quashed, my lord. I am challenging.
Why do you want the coconut trees to be removed?
My lord? Yes, my lord. My lord, kindly see, these coconut trees are leaning towards over my thatched house and asbestos room, my lord. And in the past also, due to the falling of the coconut, my wife injured and admitted in hospital also. And thereafter, my lord, police report, my lord, kindly have referred as page 29, my lord, police report is there, clearly stating that
cutting trees is not easy, sir. Why resort to 133 and all? There's one tree officer, I don't know in Orissa what they call him. This is called the tree officer. In Delhi, he's called the tree officer.
Yes.
Here, I don't know what he's called. There's a Trees Act.
Yes.
You have to seek permission under that. There's nothing like that here.
This is a very normal problem in village side. Tree is standing here, again bent on our land.
Correct. And when cyclone comes, something more
the
happens.
neighbor will suffer. I will not suffer. Although I will.
That is exactly my case, my lord.
Now the tree must have grown even more.
Yes, my lord.
You've got used to the tree, sir, now.
No.
You're living with this tree for how many years now?
My lord, but in the past also I have suffered from medical injuries, my lord. My wife has suffered.
That is not very serious, sir.
And that apart, my lord, therefore I am living.
That can happen even when you're walking on the road. So.
But there is police report also confirming that is leading towards my.
No, leading is one thing.
My lord.
That's all right. Happens all the time. So this is the neighbor's tree, is it?
My lord.
Who's appearing? You're appearing.
Yes, madam. On behalf of H.N. Mahapatra, I'm opposite.
What are your instructions?
Sorry, my lord, my senior is not available today.
Instructions are go take adjournment. Counsel to the respondent stated been some personal difficulty. Let's look for the roster bench on 8th May. Find a solution, sir.
Yes.
These are all small problems.
Item number 58.
58, your lordship, I am appearing for the opposite party. The lordship may kindly see order dated 11/3/19. This matter was dismissed for non-prosecution.
You are for the petitioner.
I am for the opposite party, your lordship.
So that appears for the petitioner. You put down his name for the opposite party. Dismissed for non-prosecution.
That was earlier dismissed also.
I know.
Item 59.
As your lordship pleases.
Right.
Item number 59.
None appears dismissed.
Item number 60.
Same order.
61.
Same order.
61 permitted to withdraw.
Dismisses.
Item 62.
None appears dismissed.
Item number 63.
But here the petitioner before your lordship is a practicing advocate at Aska Bar, my lord. And the allegation is under Annexure 5, page 17. My lord, he is a convener of a association and are doing dharana on the road, my lord. Permission was obtained. Permission, my lord, under Annexure 5 it was intimated to the police, and no overt act, nothing has been, my lord, alleged against these persons. And because of, my lord, he belonged to another party, and the petition is more than 70 years old, this FIR was lodged, my lord. There is no overt act, my lord. And it was also intimated under Annexure 5, Annexure 4 to the police that they are going to, my lord, for a dharana on 26/11/2018. Your lordship will kindly see the FIR, page 17. And nothing, my lord, is there. He is saying that they have, without any permission obtained from the police, they have, my lord, done this.
All right. You see, the perusal of the FIR shows that the allegation against the present petitioner is that, along with about 50 supporters, he blocked the NH 157 at the Biju Patnaik Chowk in Aska by forming an unlawful assembly. Stop. Apart from this, there appears to be no other allegation which would attract the string of offenses mentioned in the FIR under sections 143, 283, 341, 294, 506, and 149 IPC. The petitioner is over 70 years old, and he appears to be the convener of the Ganjam Zilla Chasi Surakya Manch. Stop. Keeping in view all of the above factors, the court is satisfied that not even a prima facie case is made out from the FIR to attract the above offences against the petitioner. Accordingly, PS case number 376 of 2018, corresponding to GR case number 739 of 2018, in ASCA PS, and all proceedings consequent thereto hereby quashed.
Item number 64.
None appears dismissed.
65.
55, permitted to withdraw to raise all these points at the time of framing of charge.
All right. Permitting the petition.
Okay.
Item number 66.
Sir, may I please your lordship? My lord, petitioner filed this application before this honorable court, challenging the proceeding in connection with 133 CRPC, my lord. Dispute in between petitioner and opposite party number 4, only because of latrine, one latrine. Whether latrine is to be used or latrine will not be used. That is the dispute in between petitioner and opposite party number 4.
Right to pee or not to pee? All right.
But petitioner...
Why don't you now settle the dispute, sir?
Lordship may...
You say that both can use.
My humble prayer, your lordship may
refer to
please
mediation.
To send the matter for the mediation center would be settled.
The courts have no work. They have to settle all this toilet disputes.
Sorry, my big brother has much more knowledge. How to settle?
More knowledge.
No, I have no knowledge.
My big brother from top to bottom, from civil court to from top court of the country. I am carrying knowledge.
No,
Let there be a toss.
this case can be referred to mediation.
Obliged, man.
Who will use the toilet? That is the issue. That issue will be adjudicated by the Mr. Das is appearing. So,
counsel for the petitioners, and counsel for who's for opposite party number 4? Opposite party.
I'm appearing for the opposite party number 4.
I see.
In fact, the dispute is something else. The dispute is that the opposite party number 4 was using a well, and the petitioners wanted to construct a latrine toilet exactly opposite the well across the boundary wall. And the opposite party number 4 apprehended that the use of the toilet would be contaminating the water in the well. And a detailed inquiry was directed to be conducted by the Tehsildar. Despite that, my lords, directly the petitioners have rushed to this honorable court instead of availing the alternate remedy available to him under the law, my lords. He can exercise his right under the 397/401 CRPC to approach the revisional jurisdiction. He's come before this court directly without exhausting his remedies. And when the matter is pending before the executive magistrate under 133 CRPC that is pending there, my lords. It's a very premature stage that he has come here.
No, but what is this 2310/2018 order? Is there some order passed?
Yes, my lords may have that order. That is at page 12.
My learned friend has not filed any objection to my petition.
No, but all that the SDM has said is cause Tahsildar will inquire. That's
Inquire,
all.
my lords. So let an inquire. So this
Only
is
an
a
inquiry has been ordered, sir. In the impugn order simply says an inquiry should be held.
Even if not to use the Latin, my lord, not only inquiry, I may be permitted to peruse, to place few lines of the order before this honorable court, my lords. Peruse the case record, it reveals that the petitioner has filed the petition under the provision of section 133 CRPs, stating the contents are submitted today. In the circumstance, I consider it proper to order directing the opposite parties to stop further construction or not to use the Latin. That is sole question, then petitioner.
No, if it is exactly opposite the well, you can shift the location somewhat. But maybe
question remains, my lord. Petitioner residing upon the place since his forefathers along with all family members. Later they created.
Why don't you shift the toilet location a bit? That's all.
OP created disturbance. That's why my humble prayer, it would be settled in conciliation center. What is problem to my friend?
All right. Counsel for the parties agree to explore the possibility of settlement through conciliation and mediation. So this is in Khurda. There's a mediation center there itself, I think.
Yes, my lords. I have no objection. It should be referred to the
both
parties.
the petitioners as well as opposite party number 4 will appear in the mediation center of the district court in Bhubaneswar on
And so I have a limited prayer.
19th April. 19th April.
Till that time, my lords, the toilet should not be utilized so that there is an interim order in my favor.
Till date, they are not using the toilet.
So there's an interim order till then, my lords.
It's okay, sir. Nothing. Whatever is there will continue till he finishes.
Let there be status quo, my lords, as it is. Let a status quo be maintained, my lords, till the mediation is decided finally, my lords.
No. The interim order is considering the submission made and considering the circumstance in which the interim order prohibiting the petitioners to use the latrine was passed at a belated stage is directed the petitioners be allowed to use the latrine constructed till the next date. The interim order is to the opposite effect, sir.
My lords, after 6 months, that order has ceased to operate, my lords.
Then just let it be, sir. Leave it be. We'll appear before that mediation center on 19th April at 3 p.m. The report of mediation will be placed before the court on the next date, listed in the roster bench on 27th June.
Lordships. Grateful, my lords.
Item number 67.
In item 67, liberty may be granted to raise all the points.
Permitting the petition.
Your lordships, I am appearing for the informant. My appearance may kindly be recorded.
Yes.
Obliged, lordship.
Obliged.
Item 68.
Lords, item 68, my lord, I am appearing for the petitioner, my lord. The ED is the opposite party.
Yes, I am for the opposite party.
Yes. Lord, here I am challenging the initiation of, my lord, second ED case, my lord, that ECAR, in issuance of second ECAR, my lord. The lordship will find it at page 49 of my CRLMC, my lord. It is on 30th of October 2018, my lord. Your lordship will see, your lordship may kindly pause it for a moment, my lord. And your lordship may kindly see at page 15. Initially, a vigilance FIR was registered against me at Annexure 1, page 15, my lord. Lordship, see that FIR was registered on 25th of May 2009, my lord. Lordship got it, my lord. My lord, your lordship may then see the occurrence of offence, that the period of that occurrence of offence, my lord, that it is between 21st of January 89.
Who's appearing for the ED? You are there.
Yes, my lord. Actually, it is a misconception of the petitioner. There are actually no case. Section 50 is a formal notice to appear and to give evidence for the purpose of investigation. No case has been registered. It has been held in Bija Madhavlal Chaudhary case. ECAR is not a FIR. Only section 50 I am reading, my lord. Section 50 enjoys the power to issue someone to any person to give statement and to submit the documents. Only thing. At this stage, we are. No case, no complaint has been filed. It is at this stage of investigation. Section 50, I am reading my Section 50.
Lord, may I just point out one thing, Lord?
Section 50, power of the authorities regarding someone's production of documents and give evidence. Civil power, civil court power is.
But you already have an FIR.
Yes.
Why have you not filed a charge sheet in that FIR?
FIR, you have not, Samagar. Till date, no FIR. It is
no, there is one FIR, sir.
FIR in
2009.
In a state business case, it is ED. ED matter is started after FIR and charge sheet submitted by the Vigilance Department, State Vigilance Department. Now, ED has initiated the proceeding by summoning the witnesses.
No, but what is the offenses you are looking into?
Offense Section 3, money laundering.
PMLA.
Yes, PMLA, yes.
So that FIR, the earlier FIR is not under PMLA.
No, that is under vigilance.
Then it's not a double case.
Yes, my lord, I am coming to him. My lord, I have two grounds. My lord, may kindly, my lord, I have two grounds. My lord, first ground is that in 2011 they issued me a summon under Section 50. I appeared. I produced the relevant documents. Then they dropped it, my lord. And again, my lord, under Annexer, my lord 4, I just now show you to
dropping is neither here nor there, sir. It's not a dropping a case is not.
But my lord, these issues are rightly now pending for the Honorable Apex Court, my lord. Now, whether my lord, just some kindly visualize one thing, my lord. The offense on the substantive offense that is under the Vigilance Act, the PC Act, my lord. That Section 13 of Vigilance Act, the PC Act, was not a substantive offense by that when the PML Act was brought into force, my lord. My lord, may kindly see. I'm just that judgment, my lord. I'm also handing over the Delhi High Court similar point, my lord, identical point. They allowed the quash the entire proceeding, and that matter has now been pending for the Honorable Apex Court. Is now.
You also know that Bijay Madanlal Chaudhary case.
In fact, my lord, Bijay Madanlal already decided. No, my lord. My lord, I'll also have brought the Bijay Madanlal
section pending. Bijay Madanlal Chaudhary is pending it.
Yes, my lord.
The Delhi High Court judgment is pending in the Supreme Court.
Yes, my
lord. Bijay Madanlal's case is disposed of judgment is there.
My lord, I'll show that judgment.
Disposed of by whom?
My lord, this is Arun Kumar Mishra and that Bijay Madanlal judgment. My lord, I will also show you to lordship. Yes. This is SLP's criminal number 10018 of 2015 that is still pending, my lord.
That also 2022.
Your lordship kindly.
707.
Yes, sir.
Bijay Madanlal's case.
My lord, your lordship may kindly come to para 19, my lord. I'll just read down. This is the exact similar case, my lord. My lord, here the offense, the date of occurrence of offense is between 21st of January 89 to 12th of May 2009. And the PC Act Section 19 was brought into the ambit of the PML Act on 1/6/2009. So these offense under the PC Act cannot be, my lord, form a schedule of offense under PML Act. This is the observation of the Delhi High Court, my lord. And that issue is still pending before the Honorable Apex Court and many
What is the period of offense for the PML Act?
PML Act. But there is no offense because money laundering.
No, which is the period, sir?
Period, yes. 89 to 2009.
So 2009?
Yes. Yes.
So where's the question? PML Act is enacted later.
No. PML Act, but Section 19 of PC Act, my lord, that was brought into the ambit of PML on 1/6/2009.
So this is before that?
Yes, my lord. That is the case, my lord.
That's it.
But yes.
Also, and in fact, my lord, that Arun Mishra judgment, my lord, that I have just now given to Lord Sim, lord, that judgment was challenged by ED before the Apex Court, and this is still pending, my lord. I have also brought that case status and the Bijay Madanlal, my lord, that recent AD judgment, my lord. This case has not been decided, my lord. This case at paragraph, my lord,
stands transferred, I think.
No, my lord.
He is not accused now.
No, these appeals
to collect for the purpose of investigation. He has been noticed to appear. He is not accused. We have not filed an FIR.
But that someone, I am challenging that someone also.
He has possessed some documents and 65 lakhs disproportionate assets has been.
But maybe it's premature, sir.
But that's, my lord, that someone is itself, my lord, cannot be accepted in under the PML Act, my lord. Because it cannot be a schedule offense under the PML Act.
Where is that, Bijay Madanlal?
Yes, my lord.
The entire 50, para 150 says with regard to Section 50.
Well, I've just highlighted that Arun Mishra judgment number, Arun Mishra SLP number, my lord. That 10018.
So it's still pending, sir.
Yes, my lord. The Delhi High Court judgment has, and in fact, that also the Delhi High Court judgment has not been stayed.
Counsel, the petitioner is relying on the judgment of the Delhi High Court in Vijay Madanlal Chaudhary versus, where is the citation?
No, my lord, that is Arun Kumar Mishra. Vijay Chaudhary is the Supreme Court judgment.
Vijay Madanlal has been already judgment has been delivered.
Yes.
This is the judgment.
No.
Yes, ma'am. This is the judgment.
No, my lord, that judgment I have just now given, my lord, that is.
No. This is part of that.
Yes.
It refers to the judgment of the Supreme Court dated. 27 July 2022 in the SLP criminal number 4634 of 2014 bracket Vijay Madanlal Chaudhary versus Union of India, in which a batch of matters which includes SLP civil, SLP criminal 10018 of 2015 referred against the judgment dated 9th April 2015 of the Delhi High Court in criminal MC 5508 of 2014 bracket Arun Kumar Mishra versus Directorate of Enforcement bracket has been detagged and asked to be listed separately. Full stop. Paragraph. Since counsel of the petitioner is relying on the judgment of the Delhi High Court in Arun Kumar Mishra bracket Supra, the present petition is adjourned, awaiting the decision in the aforementioned SLP. List on. Interim order to continue. List on. Let's move for the roster bench. On 11 July.
Item 69.
May it please your lordships. Lordship gave me liberty to file affidavit supporting the documents that CIRP proceeding, that is criminal miscase number 2057 of 2018, and this order was passed on 17th of March. So, and your lordship had directed the matter to be listed on 17th.
Okay, list this on 17th.
So I filed the along with my lords 2057 of 2018.
CRLMC 2057 of
2018. Where because of the virtue of the CIRP, the management has changed.
All right.
Item 70 also.
70 same.
Then another matter is pending millet. That is another matter is pending millet. CRLMC 3140 of 2018.
Very good.
All right. I'll list along with 3140. All right.
Interim order to continue also.
Yeah, interim order to
continue.
Much obliged, man.
Right.
I think by the vacation approaches, the High Court will be totally wiped out. We have to give us a case.
Not at all. There is enough cases.
No, much obliged, man.
All right. Yes.
Item number 12.
My lord, item 12 and 21 on behalf of Mr. H.N. Mahapatra. Sorry to say, my lord, my senior is not able to appear. So kindly maybe urgent.
All right. Counsel for the petitioner stated been some personal difficulty. I think put it off to the 28th March. All right.
Deeply obliged.
21 also. Last one.
Same.